Items for pronouncement of judgment. Item number 26, MSc Appeal 120 of 2011.
This petition under section 163A not maintainable.
Highly
He step
obliged.
into the shoes of the owner,
Oh, no, yes.
but it is assessed under section 166
Acha.
as per that Ningama judgment.
Ningamma judgment.
Yes.
And
So-
about the disability,
Pardon?
the disability part,
Yes,
That-
that has been considered.
that has been considered.
Yes.
Highly obliged.
Item 27, WPC 3937 of 2015.
Petition allowed.
Item number
Obliged.
28, Met Appeal 22 of 2019.
Appeal dismissed.
Yes,
Please, Your Lordship, I beg to mention one miss case for tomorrow. Filing number 4816 for restoration petition, my lord. For restoring the one read petition which was dismissed for
Tomorrow,
non-prosecution.
45 already in the main list.
35.
45 in the main list already.
Tomorrow not possible.
Regarding my lord compassionate appointment, the other read petition was regarding compassionate appointment.
Yes.
And similar matter already disposed of. So on that day, my lord, for non-prosecution of the council was absent. Therefore, the matter was dismissed due to non-appearance.
For sure,
Yeah.
25th, Friday, 25th.
25th of May. Oh,
25th
April.
April.
Sorry.
Yes.
My
Hello.
lord, in this case, I would like to withdraw, my lord. So let the matter be listed on 24/4, and another matter can be listed on 24 as a motion, my lord. Highly obliged.
May I please, Your Lordship, I beg to mention item number 2 and 3. In item 3, Lordship, we have sent our affidavit for vetting. Lordship may take it after 1 week.
Hmm.
He is appealing for the
I'm
petition.
preparing for the petitioner. Lordship,
Okay.
a date may be fixed kindly, Lordship.
Okay.
I will.
On the pair being made by Mr. P. Chaudhary, learned standing counsel for the
BTC, Lordship.
BTC. The matter stands adjourned to be listed on COVID.
On 5th May,
Yes.
Yes.
May I please, Your Lordship? My lord, for listing, my lord, next Monday, my lord. At
What
this-
matter?
my lord, non-payment of salary, my lord. Next Monday, my lord.
No, is there any urgency?
My lord,
If there is no urgency, then in the
urgency is
first
there, my
week of
lord.
May.
no, my lord, there is urgency, my lord. Since long time she has not received salary. my lord.
on 30th, 30,
20th of November.
28th, case আছে. On 30th, 30.
I have similar, I have also similar salary matter.
Area salary. First week of May.
First week of May.
First.
7th May, 7th May.
I'm praying for listing of this read petition, Lordship, 2020 matter, Lordship, for
When?
admission. Next week, any date?
Next week,
admission.
first week of
8th
May.
May, 8th May,
Can it be before
8th May, 8th May.
of like?
Lordship, I pay for listing of contempt case, Lordship, pending case, contempt pending case.
Wait,
Next week, if possible, Lordship.
5th May,
If may, Lordship. High level.
It means for listing a admission column, regarding area salary and pensionary benefit, madam.
first week. May first week.
28.
28,
30th May.
Last 5 years, he has not received any salary, madam.
30, 30th April.
May it please your lordship, I beg to mention one read petition to be listed in the admission column, lordship.
when?
Thursday.
In the month of
Thursday.
May, Lordship, May.
Any date may be given.
On 13th May,
30th.
May it please your Lordship, I beg to mention item number 23 for adjournment. The advocate concerned for the petitioner is out of station. Matter may come up after 2 weeks.
On the pair being made by Miss.
SD Gupta on behalf of S. Das Gupta for the petitioners.
S. Dasgupta, learned counsel appearing on behalf of Ms. S. Dasgupta, learned conducting counsel for the petitioner. The matter stands adjourned to be listed after 1 week or 2 weeks.
2 weeks.
2 weeks.
Next. May I please, your lordship? Lordship, I would like to mention item 20 of the daily list.
20.
Yes.
Well, I'm for the petitioner, my lord. Can it be on 8th of May, my lord?
8th of May.
Yes, my lord.
As agreed by learned advocates of both sides, recess shall list the matter on 8th of May.
Well, interim order is there. my lord.
Interim order passed earlier shall continue.
May I please, your lordship? I beg to mention for listing of a matter regarding service of teachers of provincialized school.
When do you want?
Can it be allowed on Friday, lordship?
No.
First week of May,
First week, lordship.
on 9th May.
Is there any urgency?
Yes, lordship.
How?
Lordship, that is the non-payment of arrear salary, lordship.
Hmm.
My service was provincialized.
Hmm.
But,
But you were receiving regular salary. You
lordship,
were receiving regular salary.
no, sir.
Alright.
5th May.
Hey, please, your lordship. Lordship, in regard to item number 19, lordship, I have a prayer, lordship. In case the matter gets called up in the first half, my humble prayer before your lordship, can it be taken up in that case at 2, lordship? Because in the first half, there is a fixed
At
matter.
2.
At 2.
Okay.
Item number 19.
Okay.
Deeply obliged, lordship.
May it be please, your lordship. Lordship, I beg to mention for listing lordship, motion lordship on the 25th, lordship.
On?
25th.
25th. Okay, like one case post.
Okay.
So items for withdrawal. 9.
Mr. S. Haq, learned counsel for the petitioner, submits that he has the instruction to withdraw this petition. That is accordingly allowed. WPC number so and so stands and dispose of on withdrawal.
With a liberty, my lord. With a liberty, my lord.
Liberty. However, liberty will remain with the petitioner to approach this court again by filing a
Right. I'm obliged.
For withdrawal, 30.
Make please, your lordship. My lord, the authority has already considered, granted the relief, lordship. So I have instruction to withdraw the petition.
Withdraw the petition. Mr.
And
K.
that-
Majumdar, learned counsel
That
for
record
the
may be
petitioner
as a part
submits
of
that.
the record.
He has the instruction to withdraw this petition. Yes. The order.
This order I supplied, lordship. Regarding deamalgamation.
As the relief claimed by the petitioner has already been granted by the respondent authorities. Fair is accordingly allowed as a WPC number as a disposal of withdrawal.
Items for admission.
I'm for a department, lordship. I'm for a department, secondary education.
Sir,
And
Okay.
that order may be a part of the repetition may be kept, lordship.
No.
Which I supplied, lordship.
if it is already complied with, is it
Lordship.
necessary?
I may pray, lordship.
Mr. Ahmed
So
has produced the produced the order. The respondent authorities that is 11/4/2025.
Obliged. Much obliged, lordship.
The respondent authorities.
Item 1 for admission.
Please, your lordship.
Yes.
If pleadings is completed in this case, it's ready for hearing. This is
Pleadings
regarding
completed.
pleadings completed. This is ready for hearing.
So when do you want?
Lordship, I am prepared today. Today I have prepared the case. Lordship,
You are prepared.
but
Yes.
Can we take up for hearing, lordship, on another date? Any other?
You were not prepared.
Not, I have not. I thought that it will be composed for hearing, lordship. Therefore.
Heard Mr.
ZZ Ahmed, yeah.
DJ
Ahmed.
Ahmed, learned counsel for the petitioner and Mr. Tobelder for respondent in
First, higher education department.
Higher Education Department. Is submitted at the part that pleadings have already been completed and the matter is ready for hearing.
Lordship.
Mr. Tobelder, learned counsel for the respondents in Higher Education Department. Submits that. The matter may be listed for hearing on
Hearing.
another date. Here is accordingly allowed. Rest shall list the matter on
Uh,
2016 matter.
on 20 May 20.
Last day,
On 13th May, Lordship.
13 May.
13. Hearing day. Much obliged.
All right.
Lordship 4 and 5 may kindly taken out of sometime. NJ Khatna, he is stuck in traffic, Lordship, for last 1 hour, Lordship. He is unable to come to the court and record the with him, Lordship. 4 and 5 both.
Okay, after some time.
After some time, Lordship. 4 and 5 both, Lordship.
Six, 7, and 8.
Your Lordship, first of all, the matter for the timing, Your Lordship. I am led by B. Bhuya, Your Lordship, senior advocate. In this case, she would like to address Your Lordship in this matter, Your Lordship. For the timing, Your Lordship.
In this particular case, Lordship, government was supposed to file affidavit.
Pardon?
BTC was supposed to file affidavit. BTC has not filed affidavit. Today also I have asked them whether you are going to file the affidavit or not.
My lord, I am appearing on behalf of each Chaudhary, my lord, London Consulting Council, PTC, my lord. My lord, affidavit has been sent for vetting, my lord.
Without affidavit, Lordship cannot take matter, Lordship.
Okay.
After 1 week, Lordship.
May I pray for a date, Your Lordship?
As agreed by learned advocates of both the parties, rest shall list the matter on when?
After a week, my lord.
After a week.
Date, Your Lordship, may kindly. Date.
13. In the meantime, learned counsel for the BTC shall file his affidavit in opposition.
I'm deeply obliged.
Item 9.
My Lord, I am for respondent number 4, my lord.
Petitioner is absent.
Petitioner is absent, my lord.
None appears for the petitioner on call. However, Mr. Soikia, learned counsel for the
Respondent 4, my lord.
respondent number 4 and madam RK Talukar for respondent number KG and
5, my lord.
learned counsel for the respondent authorities present. List the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate orders shall follow.
Item 10.
Well, matter pertains to non-payment of pensionary benefits to the petitioner. Since 2022, my lord, pension has not been paid to the petitioner.
You have retired in the year 2022.
2020.
Yes, Mr. Sharma.
On last occasion, B. Sharma, the council for the AG about to take obtain instruction. My lord.
B. Sharma.
Yes, B. Sharma.
So is he present today?
I have not seen him. After some time, maybe.
Okay, after some time.
At 2 then, my lord.
At 2. Okay.
At 2, my lord.
At two.
At 2. Huh?
Item number 9.
11.
At 2, my lord. Well,
11.
I'm very sorry, my lord. My item was item number 9. Maybe taken up at 2 more.
Okay. Okay.
Item 11.
may I please, Your Lordship?
Lord, may I pray to take up this matter along with WPC number 1484/2024. Same issue has been involved in that particular case also.
So
My lord.
whether that matter is listed today?
No,
No, my lord. My lord,
that has been reserved for order, judgment.
my lord, may I just explain, my lord? The petitioner number one herein was a teacher in the Sainik School, Gwalpara. So basing on some frivolous allegations, he was imposed penalty of compulsory retirement. Now in Sainik School, there is a provision that only the girl child of the teacher can pursue their study in Sainik School, Gwalpara. Other other girls cannot pursue. Now, while that compulsory retirement order was challenged before this honorable court, this honorable court was pleased to pass two directions, interim directions. First, not to oust him from the quarter of the Sainik School wherein he was staying. And number two direction was that allowing the daughter of the petitioner number one to pursue her studies in the Sainik School, Gwalpara. Now, my lord, what happened during the pendency of the writ petition, some indiscipline allegation were leveled against the daughter, who is a class 8 student in Sainik School, Gwalpara, and she was sought to be given transfer certificate on disciplinary ground from Sainik School. So that that order has been challenged in this present proceeding. Now, there was an interim order in the earlier writ petition also. The respondents filed an IA therein, seeking leave to pass order. Now, in that IA also, on the last occasion, just before the vacation matter came, the Honorable Court was pleased to issue notice directing the present petitioner to file the objection. Now, similar issue is pending before two courts. So that's why I'm praying, since this matter is identical to the matter in the IA, so this may be taken up along with the writ petition, the WPC 1484/2024. Although the main matter, that compulsory retirement matter was heard and judgment was reserved, but by virtue of the IA, the matter again opened up.
Not
Just
open, my
before
lord.
the
Not open, my lord. That
this
has
matter.
been reserved, my lord. That has not been open, my lord, till now. And my lord, that is civil man's 3 matter, and this is civil man's 2 matter, my lord. Completely different from that matter, my lord.
How can there be two
No, my lord.
parallel proceeding of
Not
same
parallel
issue?
proceeding, my lord. That is disciplinary proceeding, civil man's 3 matter, and this is the student's discipline as a civil man's 2
I
matter,
don't know,
my
my
lord.
lord, why my friend is objecting, but
Because
fact
my lord-
remains that in the
No.
IA, wherein notice has been issued on the last occasion, the
But Honorable Court
issue-
himself said that they are going to deliver the judgment on that case in the meantime, my lord.
The
So
ma-
it will take again time, my lord, if again but that has not been opened now, my lord. Reopened, my lord. Main case, my lord.
in the IA, my lord, the transfer certificate given by the respondents to the petitioner
IA.
number 2, that is the issue.
IA is for seeking the permission to go through the disciplinary
So
proceeding. That
therein
is
I
for
was
the IA, my
directed to
lord.
file objection.
No, that order is available before the court, order dated 8/4/2025.
Yes, my lord.
So their direction was issued to list those matters again on 1/5/2025.
Yes,
Yes, my lord.
the IA was directed to be listed on 1/5, and Honorable Court was pleased to issue notice in
My
the
lord.
IA. By that IA, the respondents prayed vacation of the interim order.
Okay, let the
My lord,
matter be
kindly
taken
see
up
last-
along with that. letter.
Kindly see the last order of my lord, this matter, my lord. Last observation by court number 4, my lord.
Yes.
Kindly see that, my lord. That, my lord, honorable sir, to take that say hand over to dispose the matter immediately, because this is a school discipline matter, my lord. That has been observed by the court number 4, my lord.
The IA came after the
My lord,
last
that-
order
how
of this.
that can be taken, my lord. One is civil man's 2 matter and another is civil man's 3 matter, my lord. How can that court take this matter, my lord, civil man's 2 matter, my lord? That is, my lord, the problem, my lord. This is particularly civil bench 2 matter, and that pending is civil bench 3 matter, my lord. How can that can be tagged, my lord?
We are concerned with the issue, my lord.
Issue is
The
completely
bench-
different, my lord. Issue
bench
is
doesn't matter.
disciplinary proceeding of the father of the father, and
Tomorrow,
this is the student,
If
my
a
lord.
hearing
No,
takes,
if the matters are taken by two different benches, then it cannot be.
Yes, but how can that possible, my lord?
in that, if that IA is, my lord, heard, what will be the subject matter?
IA is
The
completely
subject-
difficult, my lord.
What's completely difficult, my lord? Same issue. My lord, if-
Completely different, my
what,
lord, I'm sorry.
what the honorable court will decide, this issue,
No, this issue in that court cannot decide this issue, my lord. Because this issue is it is pertaining to the civil bench 2 matter, students discipline.
why they have
school
filed
matter.
the
And
IA?
this is the civil bench IA I have filed because honorable court directed not to they disturb the student during pendency of that case, my lord. The civil bench 2 and 3, how can
No,
one
my lord,
court can take
both
that
are
matter?
civil bench 2 matter, my lord.
No, my
I'm
lord.
sorry.
No, my lord. Civil bench 3 matter, my lord, that
My
is.
lord, no, civil bench 2, my lord, that is, how can school
that
or
is-
Sainik school teacher, my lord, it's a civil bench 2 matter. That matter is pertaining to, my lord, compulsory retirement, penalty of compulsory retirement of a teacher.
That is my lord, techniques of delay,
It's a
nothing,
civil
my lord.
bench
Kindly
too.
see last order, my lord. From last several days, they took time, my lord. That is nothing. Because
So
you said,
anyway, Mr. Das, if you were ready, you argue the matter.
That can also be done, my lord.
Uh,
That can also be done.
argue the matter.
My lord. I am only worried because tomorrow if the IA is heard, wherein I have been directed to file an objection, this matter will be, my lord, decided by by the honorable court, nothing else. My lord will kindly have a look at the IA. Then, my lord, things will be clear. This is the IA. These matters means IA and WPC. Same discipline, same inquiry report is in their affidavit also, my lord. Thursday, 11, जी. First of May, we should. No?
So, madam, this subject matter appears to be same.
Yes.
subject matter is, well, the subject matter of that case is that there is a disciplinary the action taken against the father of the petition, by father of the cadet, my lord. And here the case is different. That is the subject matter is that some indisciplinary act that as they are going to giving the transfer certificate, my lord. So that that report, disciplinary report is different here and there also, my lord.
Let this matter be considered by that court. The IA is listed on 1.5.
1.5, my lord.
1.5. Or Mr. Das, learned counsel for the petitioner, and Ms. A. Gayon, learned standing counsel for the respondent for this. Mr. Das submits that in connection with similar subject matter, another read petition being WPC number 1484 of 2024, and another IA being IA civil number 1049 of 2025 is pending before another bench, another coordinate bench of this court, and as such, now, and as all the matters are related to each other, the same may be listed before the court, which has already been fixed on 1/5/2025. Accordingly, it is provided that registrar list this WPC number 1086 of 2024 along with I number 1049 of 2025 before the statements.
Much obligation. Well, there is an interim order passed, my
Interim
lord.
order passed, they shall continue.
Item 12.
Yes.
My lord. My lord, the basic fact of the matter before I go to the specific facts is that the government of Assam from 2019 onwards had engaged various part-time lecturers in polytechnic colleges in the state of Assam. Thereafter, on 24th September 2024, there was a cabinet decision to absolve all of those part-time lecturers under 3F. The petitioner was excluded from the list of 3F appointees. The list of 3F appointees, Your Lordship, starts at page 40. Challenging my exclusion, the petitioner has approached this honorable court. Page 40, Your Lordship, Annexure H, is the notification which is dated 22nd of January 2025, which absorbs guest and part-time
Mr.
lecturers.
Sarma, there was a direction to Mr. K.P. Pathak.
Yes.
Lord
the law-
Standing Council for AICTE.
Yes.
Whether that instruction is available with you.
That direction was issued to me because a stand was taken by the government in their affidavit that the case of the petitioners was not considered because they have obtained a degree from an institute which is not recognized by the AICTE. So my specific instruction is that the institute is not recognized, the university is not recognized, but as there is a Supreme Court judgment which distinguishes between universities and technical institutions. So the requirement for recognition by the AICTE for technical courses is only for technical institutions and not for universities under the UGC Act or under a state act, Your Lordship. So this university ICFI is created under an act passed by the legislature of Tripura. So as per the judgment of the Apex Court, approval of the AICTE is not required. Not required. So if I may place that judgment, otherwise it is not required, and that is why it is not recognized by the AICTE.
Okay.
My lord,
this is the judgment. And this is the AICTE Act.
Which is the relevant paragraph?
Yes, if I may just take Your Lordship to the Act first, Your Lordship. Lordship may kindly have a glance at section 2H and 2I.
Yes.
Which defines technical institution Technical
consider-
institution means an institution not being a university, which offers courses or programs of technical education and shall include such other institutions as the central government may, in consultation with the council by notification in the official gazette, declare as technical institutions. And university has been defined under 2I as university means a university defined under clause F of section 2 of the University Grants Commission Act 1956 and includes a definition institute deemed to be a university under section 3 of that act. Now, if I may take your lordship to section 10, which lays down the functions of the council, the AICTE. Lordship may have 10K, your lordship. So, grant of approval for starting new technical institutions and for induction of new courses or programs in consultation with the agencies concerned. So, this prior requirement of prior grant of approval, Supreme Court has held, is only for technical institutions.
Not for universities.
Not for universities. If I may take your lordship to the judgment now. So what had happened, your lordship, is that the AICTE itself had filed a writ petition before the Madras High Court saying that all universities should also come within its ambit. So without getting prior approval of the AICTE, no university should also be allowed to start or conduct a technical course. So the single judge, the division bench of the Madras High Court, your lordship, accepted the submissions of the AICTE in the matters. The matter went before the Supreme Court. The Supreme Court held that since a distinction has been made in the Act under Section 2 and 10 between universities and technical institutions, and Parliament was aware that universities are already governed by the UGC Act. So the requirement of prior approval of the AICTE is not required for technical institutions. But the Supreme Court said that universities should try and follow the norms which the AICTE lays down. It does not mean that those norms should be disregarded. If I may just take your lordship to the relevant paragraphs. Paragraph 15 is where the Supreme Court sums up the findings, your lordship.
15.
15. Page 689. Paragraph number 15, 689. Page number 6.
There is a mistake in presentation.
Lordship may have, I beg your pardon.
The last two pages are different.
Exactly. Lordship may have this. I beg your pardon. I beg your lordship's pardon.
Yes.
Paragraph number 15 at page 689. To put it in a nutshell, a reading of section 10 of the AICTE Act will make it clear that whenever the Act omits to cover a university, the same has been specifically provided in the provisions of the Act. For example, while under clause K of section 10, only technical institutions are referred to, clause O of section 10 provides for guidelines for admission of students to technical institutions and universities imparting technical education. If we look at the definition of a technical institution under section 2H of the Act, it is clear that technical institution cannot include a university. The clear intention of the legislature is not that all institutions, whether university or otherwise, ought to be treated as technical institutions covered by the Act. If that was the intention, there was no difficulty for the legislature to have merely provided a definition of technical institution by not excluding university from the definition thereof, and thereby avoided the necessity to use alongside both the words technical institutions and university in several provisions in the Act. The definition of technical institution excludes from its purview a university. When by definition a university is excluded from a technical institution, to interpret that such a clause or such an expression, wherever the expression technical institution occurs, will include a university, will be reading into the Act what is not provided therein. The power to grant approval for starting new technical institutions and for introduction of new courses, this is relevant, Your Lordship, or programs in consultation with the agencies concerned is covered by section 10K, which would not cover a university but only a technical institution. If section 10K does not cover a university but only a technical institution, a regulation cannot be framed in such a manner so as to apply the regulation framed in respect of technical institutions to apply to universities when the Act maintains a complete dichotomy between a university and a technical institution. Thus, we have to focus our attention mainly to the Act in question on the language adopted in that enactment. In that view of the matter, it is therefore not even necessary to examine the scope of other enactments or whether the Act prevails over the University Act or effect of competing entries falling under entry 63 to 65 of List 1 vis-a-vis entry 25 of List 3 of the 7th schedule to the Constitution. Para 16 bears some relevance. The fact that initially the syndicate of the appellate university passed a resolution to seek for approval from the AICTE and did not pursue the matter on those lines thereafter, or other similar entities were adopting such a course for obtaining the same, and that the Andhra Pradesh High Court in M. Sambasiva Rao had taken a particular view of the matter, are not reasons which can be countenanced in law to non-suit the appellant. Nor such reasons could be relevant or justifying factors to draw any adverse finding against and deny relief by rejecting the claims of the appellant university. We also place on record that the statement of the learned senior counsel for the appellant, which in our view even otherwise is the correct position of law, that the challenge of the appellant in reference to the regulation in question and the claim of the AICTE that the appellant university should seek and obtain prior approval of the AICTE to start a department or commence a new course or program in technical education does not mean that they have no obligation or duty to conform to the standards and norms laid down by the AICTE for the purpose of ensuring coordinated and integrated development of technical education and maintenance of standards. So the legal position is that though recognition is not necessary, but they still have to conform to the standards laid down by AICTE.
Why that question arises in this petition?
Because the stand taken by the respondents, state respondents, in their affidavit is that the case of the petitioners was primarily not considered because they obtained a degree from ICFA University, Tripura, and that is not recognized by the AICTE.
Okay.
So my instructions, if I may just place it, Lordship may perhaps like to keep this on record. This is my written instruction. At the bottom of the page, Your Lordship. First page itself. At the bottom of the page, starts with Sir, Madam. This is to inform you that Institute of Chartered Financial Analysts of India, ICFA University, Tripura, is not approved by AICTE. However, clause 1.1G of AICTE approval process handbook 2024-27 may be referred to. Same is reproduced as under 1.1G. It is not mandatory for state, public, private universities and central universities to take AICTE approval as per the AICTE Act. However, universities shall seek approval of AICTE for availing the benefits of AICTE scheme/stroke initiative as per the prevailing policies norms to maintain the standards and norms as prescribed.
Okay.
So that is my instruction.
Yes, Mr. Sharma.
Yes. My lord would kindly come to page 10 of the writ petition.
Page 10.
10, Your Lordship. Page 10.
Mr. Pathak, you may go. Your part is over. Page number 10, yes.
Page 10, Your Lordship. My lord will kindly come to paragraph number 15.
Yes.
That the petitioner, before publication of the notification dated 22/1/2025, where my name was excluded, was verbally informed by the offices of the respondent number 2 that his candidature may not be considered for absorption under Regulation 3F, as the petitioner had obtained his BTech from ICFA University, which had not yet been approved by the AICTE. That the law in this regard is clear and has been further fortified by legal precedents that a university, like the ICFA University, which is approved by the UGC, does not fall within the ambit of a technical institution as defined under Section 2H of the AICTE Act, vis-a-vis the provision of Section 10(1)K, which my friend had just read out before this honorable court, which empowers the AICTE to grant approval for starting new technical institutions and for introduction of new programs. Now, Your Lordship will kindly come to paragraph number 17, which refers to annexure I. Annexure I, your lord, is at page 45. Page 45. Page 45. This is a letter by the UGC themselves, where in the last point, your lordship, point number 3, ICFI University Tripura is not required to take approval of AICTE to run the BTech courses. And in the affidavit of the government, my learned friend had furnished before me, page number 70, page 70, paragraph number 10. Yes, that the deponent begs to state that the meeting of the said committee held on so-and-so reviewed the application of the petitioner along with his educational documents. As per minutes of the meeting, the petitioner obtained his UG degree in engineering from the institution which is not recognized by the AICTE. The petitioner obtained his Bachelor of Technology degree in mechanical engineering from an institute, namely the Institute of Chartered Financial Analyst of India, Tripura University, Tripura. The degree, certificate, and the syllabus of the BTech degree in mechanical engineering obtained from that particular institute have been enclosed. That is the only ground which should have been taken for exclusion of my name. There are no other grounds. And in fact, I was verbally informed, which had occasioned me in preferring representations before the authority, that ICFI does not need to have BTech, does not need to have the AICTE approval. Now, that is my case. That is my case. That is the only ground that they've taken in excluding my name from the list of 3F appointees. My friend from the AICTE has already clarified the stand, and that stand has also been clarified in the writ petition also, because we were intimated verbally that your case will not be considered because ICFI does not have AICTE approval. Pursuant to that, your lordship might like to see annexure number J, which starts at page 47 in the writ petition itself, page 47 onwards. This is before the publication of the notification of 22nd of January. Respected sir, madam, I am so-and-so, TT appointed part-time lecturer of Mechanical Engineering branch of Buxa Polytechnic, Assam. With due respect, I want to inform you that a small confusion has occurred regarding a UGC-approved university needs AICTE approval or not for technical courses. It is clearly mentioned in Supreme Court verdict, AICTE approval guideline, and in UGC guideline that the UGC-approved state self-financed private university or state government university need not to take approval of AICTE for technical courses. All of these representations had gone unanswered before the authorities had published the impugned list where my name was excluded. That is my case. That is
Yes, Mr. Das.
My lord, kindly have page 747 of this, my lord, where says, my lord, academic qualification for direct recruitment, my lord.
Page number
747.
Seven.
747.
747. Yes.
But this says the minimum academic qualifications and experience of a candidate for direct recruitment shall be as prescribed by AICTE from time to time as adopted by the government of Assam. That means, my lord, the Assam government candidates in technical education, my lord, the requirement of Assam government is that they have to, my lord, the courses have to be as per the norms of AICTE. And my lord, as per my instruction also, this institute has to be, my lord, recognized by the AICTE. My lord, my lord, my humble submission would be, my lord, since my learned friend has submitted one my lord, judgment, and I have, if my lord may give me 2 or 3 days time, my lord, I will go through it and also clarify whether Assam government requires the institute to be recognized by the my lord, AICTE. Although because as
there is a decision of Supreme Court.
Yes, ma'am.
So your instruction will not change the legal purposes.
My lord, what I have understood, my lord, from the judgment read out by my friend, my lord, it says that since UGC, the university, does it, the technical, the university established under UGC, and for imparting technical education, it doesn't need the AICT approval as per this concern Tripura University. My submission is that in Assam, if Assam government, the requirement of Assam government is that for employment, the candidate has to be pass out from a recognized university under AICT. That will bring some distinction between the Supreme Court judgment and the requirement. That's why if give me 2 days time, then I'll clarify this position.
Yes, any other respondents?
Not received the instruction, Lordship.
Pardon?
Not received the instruction. Yes.
You are for?
UGC, Lordship. Responding number 3.
UGC has already clarified. It's a part of the record. No further instructions are needed in that regard. And the law is clear.
Whether further instruction is required? Mr. Soma has already shown the instruction.
The UGC cannot confirm whether the AICT will have to grant approval or not. The AICT Council has clarified that AICT approval is not needed. And the act is clear. It's a central act, the AICT Act. A differentiation has been made between an institution and a university.
But the letter annexed by my friend Malad and shows the university is saying that the UGC is saying that this concerned University of Tripura University doesn't require approval of AICT.
So tomorrow there cannot be a
that
separate
question
instruction.
is also there, Malad, whether UGC can say that whether AICT approval will be.
No, the decision of Supreme Court is there.
Yes, my lord, it is there. It's law as of now.
The only fact is that, Malad, what my submission is that whether Assam government requires candidates to be pass out from AICT recognized university or not, Malad. Only that much I have to clarify, Malad. If requirement is that the candidate has to be passed out from a AICT recognized university, then Malad, this case will have
No,
some.
that proposition has already been cleared by the Council for the AICT.
Yes.
No, Malad, what my understanding is saying is that, Malad, the Supreme Court judgment says that university can also run technical education, and for that, this particular university doesn't need AICT recognition. My submission is, Malad, whether the requirement of Assam government is that the candidate has to pass out from mandatorily pass out from AICT recognized university. They may, some universities may be there where they are allowed.
We reserve the judgment.
Yes, my lord.
You obtain
lord,
instruction and apprise this court within 2 days from today.
My lord, there is another judgment I would like to place before this honorable court for payment of consequential benefits. Thank you. For payment of consequential benefits. My lord will kindly come to page 157, paragraph number 6.
Yes.
When fixing the back wages, several factors need to be noted. It is a well-settled position in law that on reinstatement, there is no automatic entitlement to full back wages. In Hindustan Tin Works Private Limited versus Employees, a 3-judge bench of this court laid down. In the very nature of things, there cannot be a straitjacket formula for awarding relief for back wages. All relevant considerations will enter the verdict. More or less, it would be a motion addressed to the discretion of the so-and-so. Full back wages would be the normal rule, and the party objecting to it must establish the circumstances necessitating the departure. At that stage, the tribunal will exercise its discretion, keeping in view all the relevant circumstances, but the discretion must be exercised in a judicial and judicious manner. The reason for exercising discretion must be cogent and convincing and must appear on the face of the record. When it is said that something has to be done within the discretion of the authority, that something is to be done according to the rules of reason and justice, according to law and not humor. It is not to be arbitrary, vague, and fanciful, but legal and regular. So the aspect of my exclusion from the 3F list based on the institution not being AICTE approved goes contrary to the AICTE Act and goes contrary to the law which has been laid down by the Honorable Supreme Court. And in that regard, Your Lordship, my humble submission before this Honorable Court is that since the only reason for my exclusion is based on an erroneous reading of the law by the Assam government, I should be entitled to the entire consequential benefits of the past 2 months when my similarly situated colleagues and peers were absorbed under 3F. That is my submission. I'm grateful, my lord.
Heard Mr. Sharma, learned counsel for the petitioner. And Mr. K.P. Pathak, learned secretary counsel for the AAC. And Mr. S. Das, learned counsel for the respondent in higher education department. And Madam for? For H? H. Samoa, learned standing counsel for EGC. And you?
KP Patha was.
Argument concluded. Judgment reserved.
I'm grateful, my lord.
Well, I will place if I find
Yeah,
something
so
within
within 2 days,
Yes, yes.
you can file it through the court master.
Yes, miss.
I'm grateful, my lord.
Number 13.
This is a contempt matter of 2017, my lord.
But I have been newly included and I am appearing on the resolution 3 and 4. On last occasion, Lordship, my friend was not appearing in this content. Anyway, Lordship, I need some time. Lordship, I have received instructions, but I need some clarification from the district, Lordship. Let it come on next week, any date, Lordship.
Not next week, the after 5th May, any day.
After
5th May.
5th May. Heard Mr.
Any day.
Oh, sorry, learned counsel for the petitioner and Mr. Sisti
Date may
for-
kindly fixed, man. Date may kindly be fixed.
Mr. Sisti for the respondents. Number 3 and 4.
3 and 4. The
Three
newly
and four.
included.
Mr. Sisti submits that he has newly been engaged and he may be granted some time to obtain necessary instruction. The price for listing the matter after a week. Here is allowed. This is the list the matter on.
Oblige you.
Sorted.
In the 5th to
9th May.
March.
Oblige you.
March.
Item 14.
May I praise your lordship? Lordship may peruse the last order dated 1st of April 2025.
Here, Lordship, the director has already issued an direction to the inspector of school to release the salary, current salary. I have also telephoned, have a conversation with the inspector of school. He is releasing the salary very soon, Lordship. Yes. Within this week. Let it come on next week, Lordship. This item. I will give the up to the instruction, Lordship.
Heard Mr. A. Supravati, learned counsel for the petitioner and Mr. Sisti, learned standing counsel for the respondent of court. Mr. Sisti submits that
Director has
matter
already
will be
instructed.
listed after 1 week.
Yes.
Okay.
Yes. Oblige. Oblige you, Lordship.
Oblige.
So as to enable him to obtain up to date inspection here alone.
Oblige.
Oblige.
15.
My lord, kindly peruse the order of the at page 14, my lord. Direction is given to the respondent to submit. There is some urgency that petitioner will retire on 34/2025, my lord.
Who is for respondent authorities?
1 and 2 not served, my lord.
1 and 2?
Not served. 3 and 4, 5 appeared all Angus Council. Main respondent is respondent number 2. my lord.
Respondent number 2.
2. Higher Education Standing Council may be on behalf. Confirm party chart. Higher Education.
And Madam, you are for?
Instruction, I'm with CAG.
You are for?
Accountant General.
Accountant General.
Particular instruction, that our office may be dropped, our name may be dropped because we have no law. Maybe the pension that will be paid by the Mizoram University, not our office.
Heard, Mr.
TLA on behalf of Mr. D.K. Roy.
Learned Counsel, appearing on behalf of Mr. DK. DK?
Roy.
DK Roy, Learned Counsel for the petitioner, and Mr.
D. Sharma. Deep Jyoti Sharma.
Learned Counsel for respondent number?
5.
Respondent number 5, and Madam Tinlong for appearing on behalf of Mr. R.K. Talukdar, Learned Standing Counsel for KG. Respondent number 4. And you?
Respondent 3, Your Lordship.
R.M. Borua, Learned Counsel for the respondent number 3. Respondent number 3. Office note dated 10/4/2025 indicates that neither edited nor answered notice in respect of respondent number 1 and 2 has been received by the registry. Accordingly, it is provided that Learned Counsel for the petitioner shall take precessive upon respondent number 1 and 2. Ms. Tinlong, Learned Counsel for the respondent number 4, has produced one written instruction received by Mr. R.K. Talukdar, Learned Standing Counsel for the respondent number 4, that the respondent number 4 has no role in the present proceeding, and as such, the name of respondent number 4 may be struck out from the array of this petition. Is any objection?
No, my lord.
No objection.
Main respondent is respondent number 2, my lord.
Main. The learned counsel for the petitioner submits that he has no he has no objection in the event of speaking out the name of respondent number 4 from the array of this petition. Whereas taking note of the submission of learned counsel for both the parties, it is provided that the name of respondent number 4 is struck out from the array of this petition. List after 4x. You
My lord.
take a step upon respondent number 1 and 2.
Maybe short date given, my lord. It is
After
not
2
written.
weeks then.
Huh?
2 weeks.
Obliged.
Items, this is 16.
My lord, in this matter relating to, my lord, the issuing of the NOC from the government in respect of the private institution is required or not, that is the, my lord, issue here. But as per, my lord, the provisions of the UGC affiliation guidelines and the, my lord, BCI rules under which, my lord, I applied for the approval for starting my LLB course. But it is specifically showing and specifically, my lord, stating that no NOC is required in case of the, my lord, private institution. But this is the case, and the UGC, my lord, the Guwahati University advocate, my lord, PJ Fukan also, he appeared and submitted his affidavit also. In the all the time, he never present. This is the difficulty, my lord. And, my lord, in this case, my lord, our party has, my lord, went to the Supreme Court also for a direction so that, my lord, this matter will be expeditiously heard. And we got the copy also. In last occasion, 2-3 times I submitted and I repeatedly requested him. I don't know. But then why I started.
Court sir will contact him. Wait for some time. Let Mr. Fukan come.
My lord, here the, my lord, petitioner foundation is a, my lord, registered.
PJ Fukan sir is not available. Kindly pass over the matter for
Not
time.
available today.
He's there, but he's not receiving the call right now.
After some time. Mr. Mohanta, after some time.
Matter is very small issue, my lord, but.
Okay, we will take it up.
Yes, my lord. I want to disposal to my lord.
Okay.
Pending item 5.
He was here, your lordship. Few minutes back. He was here, your lordship.
This matter is still under consideration of active consideration of government, madam. I will be granted 2 weeks time, madam. 2 more weeks time so that I can send a
fixed date.
latest instruction, madam.
Okay. Part Mr. Portapur, learned counsel for the petitioner, and Mr. N.J. Katonia, learned standing counsel for the elementary education department, and Mr. Borafo, SSA. Mr. Katonia submits that the issues raised in this petition is actively under consideration of the respondent authorship, and if raised for granting in 2 weeks' time, there is a law, necessarily is the matter on
14 May.
14.
Lords. Obliged.
Pending item 4.
In 4 also, madam, I am praying for some more time, madam, because others pleadings are complete, madam. I need some time to prepare the brief, madam.
Part Mr. A. Dekkal, learned counsel for the petitioner, and Mr. N.J. Katonia, learned standing counsel for the respondent in elementary education department. Mr. Katonia submits that he may be granted some time to file affidavit in opposition.
No, we have filed the affidavit, madam. We have filed the opposition, madam. They have filed to reply. Also some time to prepare the brief, madam.
Acha. Price for granting him some time to prepare the brief. There is accordingly allowed. This is the matter after 1 week.
Yes, madam.
No, sorry, date. 16th of May. 16 down. Can it be 15 Lord on 16 Lord? 15th of May. On a hearing day because already pleadings complete.
Okay.
15th of May.
Okay.
Item 31.
May I please, your lordship? Lordship, matter may be come on page day for
Pardon?
admission.
Pardon?
My lordship, matter may be
May I play Lordship? Lordship, here in this case, I am for the response number one. And response number one yesterday, yesterday engaged learned AG in this case. And he is on legs and pays for fixed it on your Lordship 24.
24.
24.
Okay. Okay, awesome.
Next Tuesday, 29.
Okay. As agreed by learned advocates of both the parties, recessal is the matter on 24th.
Item 32, Parhad.
Number 32, Lordship, we are asked to file an affidavit, Lordship. We have filed the same today, your Lordship. So Lordship can take up the matter either tomorrow, Lordship, or on Friday, Lordship.
at 2 p.m. my lord. We're ready, my lord.
It has to come on record also, Lordship, either tomorrow or on Friday, Lordship.
It can be call me lord.
Today.
At 2 p.m. Today at 2 p.m.
In case they would like to file a reply to the same, Lordship.
No, my lord,
Sure.
no.
Either tomorrow or on Friday.
Let's see at 2 p.m. my lord.
Right.
Because the affidavit can be called for at 2 p.m. my lord, we'll see if necessary.
File it.
I filed it, Lord.
Copy to distance.
Shall we file this morning, my Lordship? What can take it up tomorrow or not?
Getting it. So Thursday then,
Lordship.
affidavit is not available. What to do?
Lordship.
It is not shown in the computer also.
Lordship can call it for it, Lordship.
Heard Mr. Goswami, learned counsel for the petitioner, and Mr.
And bottom, Lordship, I'm for the respondent. All the
Gautam,
respondents.
learned counsel for the respondent. Mr. Gautam submitted that he has filed his affidavit today morning.
Lordship.
And the same is not placed on record, and accordingly it is provided that rest the list on after day after tomorrow.
Lordship.
Tomorrow also we
The
are ready, my
affidavit
lord.
filed by the
Tomorrow even we are okay, sir.
Tomorrow-
we are okay, Lordship.
Tomorrow we
tomorrow. Okay.
oblige, my lord.
Item 33.
Well, that's this contempt proceedings. Provisional pension not released even, my lord, the contender has not also is submitted the final pension paper. That is why, my lord, the order has been passed in full for, I have placed it here for your lordship. Yesterday, I have placed. Court has been shocked and considering for personal. So 14 months is without any penny, my lord, in spite of the direction.
Lordship, Lordship may say the order dated 15/5/2024 against which the contempt was proceeded, Lordship. Lordship, in that order, Lordship, it was written that pendency of the writ petition shall not be a bar to process and release the provisional pension of the writ petition. So, Lordship, there was no clear direction to release the pension, Lordship. The order says that writ petitions, pendency of the writ petition shall not be.
Page 10, kindly see, my lord.
And the provisional pension has already been released, Lordship.
Page 10, kindly see, in the interim, the respondents are directed to release the provisional pension of the petitioner, my lord. After that, my lord, page 20, kindly see, the secretary, deputy secretary and director has instructed this inspector, this is contemner, to comply with the High Court's order, my lord. He is testing the teeth of this order, my lord. I don't know what happened to this.
There is specific direction to release the provisional pension.
Yes, my lord.
So you have released the provisional
Yes,
pension.
yes, Lordship, on 29th of March, Lordship.
Where, my lord? In last occasion, 4/4 order, my lord, when main case was listed, they cannot come with a clear cut. That is why with all records 25/4 it is fixed, my lord. And if not, then personal appearance should be considered. This is the order, my lord, I have placed. So
Yes,
there,
Lordship, in the writ petition, we will file our affidavit, Lordship.
If pension matters, my lord, there is a direction, my lord, it's a clear cut violation.
Pension has already been released, Lordship.
The instruction is not correct, I think. Let me personally come with signatures.
Lordship may give us 2 days time to file our affidavit. Lordship, we will file all the.
Why affidavit is necessary? You have to comply with the order of this court.
Yes, Lordship, we have released the provisional pension, Lordship, and one thing is, Lordship, for releasing the pension, we have to upload all the documents in the Greater Gata portal, Lordship, and we are proceeding with that thing, Lordship. That's why we would like to file our affidavit, Lordship.
My lord, they are playing with these orders, my lord, I am sorry to say. So it's some,
Lordship,
because
maybe
inspector
2
school is
days time,
there.
Lordship.
Director is also instructed him, director and deputy secretary, that comply with the high court orders, release these pensions. This inspector himself is a adamant.
Why?
I don't know, my lord, he is not satisfied otherwise, or in something personal is there, I don't know, my lord. That is why he should answer it, my lord, and this instruction is not correct, my learned friends, my lords. They should come with this copy that this pension is released, only submission, my lord, and
So,
taking
where
time.
is the order?
My lord,
This has
page
not been
10
complied with? Page number?
not comply. Well, page 10 is the direction, my lord, and page 20, kindly see that there is the direction from Deputy Secretary Education to Inspector of School. That is container, my lord. He is the main. In this regard, you are required to take necessary action, observing on the formalities, complying the Honorable High Court's order. This is the order direction given to him long back, my lord. 8/10/2024 in October. Not only sitting on this direction by High Court, he's sitting on this order of this government also, my lord. So something is there, my lord.
No, Mr. Borua.
My lord.
So this order appears to be complied with.
And there is
order
this.
dated 25/9/2024. They have released the provisional pension. They have released the provisional pension.
Yes. So last occasion, before that, they should supposed to file an affidavit complying orders. That affidavit they have not filed. Now they are, my lord, doing the we file affidavit like this. This is a provisional pension, my lord.
No, they have already released. They have complied with the order.
My lord, where is the compliance order, my lord? They have to file affidavit. There is no order, my lord.
No.
There is no order, compliance order affidavit directed before the.
No, you have not received the provisional pension.
No, my lord, no penny is received till today, my lord. And I am sorry to say, something is asked from him, my lord. That is why he is just pillar to post is moving. And not to government or deputy secretary, the DSC, only this inspector. He is doing everything, my lord.
Lordship may give 2 days time, Lordship. We will file our affidavit with all the.
My lord, that day also there is.
No. Why affidavit is required? You are to release the pension.
As per the instruction that I have received, Lordship, the pension has already been released on 29/3 of this year, Lordship.
You obtain verbal instruction, we will take it up at 2 o'clock.
Yes, ma'am.
Okay, Lordship.
Otherwise, we will direct you to remain present in the court
Yes, Lordship.
at 2 p.m.
Timing item 16.
That is Swagini answer. The affidavit file kora nahi, they are not filing. But they say they will not filing affidavit. Already submission is there. But regarding Bar Council, my lord, they have stated that they are not going to file any affidavit, my lord. In the Bar Council, Canning Council, Pritam Mahota is submitted in the court. Only that is recorded also.
But my lord, the Bar Council of India stand would be required, my lord. It's highly important.
But they specifically well stated, my lord, the junior also here. In Pritam Mahota, my lord, lordship in order, I probably, my lord, the
affidavit may not be filed, my lord, but the legal proposition, the legal stand of Bar Council of India as regards this private institution.
Well, the document I relied, this is the Bar Council guidelines,
part will-
2010. It is a two document I relied, one of the from the UGC guidelines regarding the affiliation and the Bar Council guidelines. In both the documents, it is specifically stated, only in case of the private institutions, NOC is not required. And the affiliation guidelines of the UGC, it is specifically stated that everything will be guided by the statute and the statutory authority, and who will be the statutory authority to that regard also, that is been defined in the UGC guidelines, my lord. So I am on that. My lord, lordship will come. Here, my lord, the nutshell, I have given the, my lord.
So this I is for what purpose?
IA, my lord, this is, I have not now, at present, I am not pressing, my lord. The IA was that, only the anticipation that I will get the approval. So there is a, my lord, deadline in December 2022 to submit the, my lord, the affiliation fee and other things. So I have deposited 6,50,000 to the Bar Council. My lord, that in anticipating that I will get the, my lord, proper, my lord, affiliation from the university. So that, my lord, that was the last date. So now they are saying that they, although I have, my lord, submitted and deposited the amount, that will be offline mode. That will be not considered even if, my lord, my petition is allowed, and they will deduct the amount after deducting the certain amount. So that is, I prayed that if this my affiliation is, my lord, getting from the university, then, my lord, they may consider the my amount that is already been deposited for giving the preliminary approval, my lord. This is that, right now I am not pressing, my lord.
May I interrupt, Miller, before opens up in the merit aspect, Miller? Miller, since Miller, it is revolving around only one aspect, the NOC. NOC from government. Miller, my learned friend's contention is that it is not applicable to private institution, private college. But the Bar Council of India's stand would be required, Miller, whether it would be applicable, whether NOC is required for private institution from the government of Assam, Miller. And government of Assam's affidavit, as well as university's affidavit, is clear that NOC would be required even for the private institution.
From Bar Council?
No, my lord. This is, I don't know, my lord, from my lord.
NOC from
Where from
state
submitted, my
government,
lord.
That is the OM, Miller, Office Memorandum of the state government.
Whether,
And that
my
has
lord,
No,
been,
no, the NOC from which institute? Sir?
Miller,
NOC from
from the
from
government,
state
my lord.
government,
From the government.
government.
state government.
My lord, my question is, my lord, whether the OM came, my lord, override the, my lord, statute.
So
This
that,
is the thing,
that
my
is why,
lord.
Miller, that Bar Council of India's stand, whether that NOC would be required for private institution or not. That is vitally important. Miller.
No, who is
My lord,
appearing
lordship,
for Bar Council?
my lord, I have annexed the document, my lord. This is lordship will get the page, my lord, that it is started from 33. Lordship will get the provision, that is at page 36, my lord. It is Bar Council, my lord, guidelines. I have annexed this document and full guidelines also with me, my lord. Where it is, lordship will get it, clause 6, my lord,
Page number 30,
36.
36.
Yes, my lord. This is chapter 2. It is a, my lord,
Chapter 2,
guidelines
yes.
for 2010 Bar Council, my lord, where it is application for initial approval. Heading is this. The lordship will get, my lord, clause 6. It is specifically stated that in case of the state funding institutions or institutions seeking fund from the state, public union, government, a statement from the relevant government for no objection to the application of a specific preliminary approval or sanction for the establishment of the institutions. University, faculty, department would, however, not required for same, but has to submit the resolution from the various authorities required, but the establishment would shall also be accompanied by the act, rules and regulation of the university. Well, it is specifically stated the NOC is required in case of a state funding institute, my lord. If I am going for apply for any state funding or any state assistance for claiming for any provincialization, in that aspect only the NOC is required. And lordship also come to the next page also. Here it is, the heading is started from the periodic inspection, is the last part of the last line of the page number 36. Under that head, again on clause 6. Why I am, my lord, insisting on the affiliation from the university, my lord. The copies of the affiliation letter, if it is an affiliated institution from the university, NOC from the relevant government, if it is a state-owned or funded institution, my lord. must be submitted with the applications, my lord. So it is also specifically again saying that if it is the state-owned institution or state funding institution, then only NOC is required. But in case of the private institution, it is not required. And moreover, my lord, lordship, the UGC also followed some, my lord, guidelines regarding the affiliation, where I have, my lord, mentioned in my petition also. It is lordship will get at page. I reproduce the, my lord, the provision. My lord, para 8 of my petition, my lord, page 13. My lord, the petitioner beg to state that as per the provisions of the regulation 3(1) of the regulation 3 under the UGC affiliation of college by the universities, regulation 2009, herein after referred to regulation, the provision, my lord, the proposed college seeking affiliation at the time of the inspection by the university shall satisfy the following requirements or the requirement in respect of any of them prescribed by the statutory regulatory body is concerned, whichever is higher. Next, my lord, moreover, the statutory regulatory body as mentioned in regulation 3(1) is defined in regulation 2.6, where it is, my lord, below, my lord. Statutory regulatory body means a body of constituted by this central state gov act for setting and maintaining the standard in relevant area of higher education, such as All India Council for Technical Education, AICTC, Medical Council of India, MCI, Dental Council of India, DCI, National Council for Teachers Education, NCTE, and last one, my lord, Bar Council of India, BCI. So, my lord, my entire procedure will be as per the statute and guidelines of the BCI, my lord. It is there, my lord, the UGC guidelines, they have admitted that as per this provision will be followed. So BCI says that if the institution is a private institution, NOC is not required, my lord. So my prayer is, my lord, my institution is purely private institution, not only one. I have already started, my lord, 6 institutions, all are running. And after immense success in all the institutions, now I am coming to establish a law college under the name of Ham AK Real Law College, my lord. For which purpose I applied for the affiliation, because affiliation document is very much mandatory for applying the prior approval from the BCI to start my LLB course. So this is pending. It is since 2024, my lord. Now no decision has been taken by the authority concerned. Still it is pending. Now they are saying the common notification by 24, this is, my lord, on 25, 24/5/2020, 22, whereby it is saying that the, my lord, those applied for the NOC affiliation, they have to first obtain the NOC from the government, and instruction was given to all the institutions whose case is still pending. First approach to the government for NOC, and after getting the NOC, they should submit before the University College Development Council for further action for affiliation. So complying that notification, now they are insisting upon me also that I should approach to the government for NOC. But the BCI rules saying that is also on the basis of the UGC guidelines 2009, specifically stated that there is no NOC is required from my private institution, my lord. So what is the requirement of the now NOC? They are insisting again. So BCI also very much clear. All the provision, their UGC guidelines also very much clear.
So what is the stand of the government?
Government is nothing, my lord. They are not saying anything, my lord. They are not insisting that I should get the NOC from the government, but they are only insisting one OM, my lord. This is I have also annexer at page page 27, my lord. This is the OM. This OM was, my lord, published, my lord, only to prevent the, my lord, mushroom growth of the institution after, my lord, the enactment of the Assam Education Provincialization of Teachers and Service and Reorganization of the Education Institution Act 2017. So that, my lord, no further mushroom growth institution may be, my lord, coming up, and subsequently they are paying for the any government assistance of the provincialization. To prevent that things, my lord, the OM was, my lord, published. That as per this OM, my lord, Lordship will get the provisions under section, this is page 27, my lord, annexure 5. It is section 1, subsection 3, my lord. It is heading the prior no objection for obtaining the new colleges. Heading is this, under which my lord 3 is said, when the university concerned seek prior no objection from the government for opening a new college, the government will take necessary action for inspection of the college concerned through its Director of Higher Education. And my lord, this here, my lord, degree colleges means, my lord, I am coming, my lord, the definition is 2 of subclause 4, Roman, my lord. Just ahead of this, my lord, section 1. Definition here, degree college, my lord, specifically says degree college means the college imparting general education for 3 years degree courses in arts, science, and commerce. So my case is, my lord, this is not a degree course, my lord, this is a postgraduate, my lord. And moreover, my lord, we are imparting education 3 years LLB as well as for 5 years integrated course. So this is not all come under this purview also. And OM cannot be, my lord, supersede the statute. I am on the statute, the Bar Council is a statute, Bar Council BCI Act is a statute, my lord. And the UGC regulation, that is also a statute. So how the OM can override this case provision? This is, I think, my lord, this is an unwanted thing, my lord. This OM, wherever they are relying, that as per the EC, my lord, meeting that was held in 2022 March, my lord. On the basis of that, they are saying that the NOC is required, and as per this, my lord, complying this and EC meeting, they have issued another notification on 24/5, by which they are saying that if those cases are pending, they have to approach to the government for NOC. And first you have to NOC obtain, then you approach to the College Development Council for further action of the affiliation. But in my case, my lord, vehemently, my lord, stating, my lord, that there is no provision for NOC in my case, because my institution is a purely private institution, and my communication, lordship, your lordship will get it page Annexure 3 at page 25. This is the second reminder. The first one was where that was filed on Annexure 2 at page 3. March 31st, well, I have submitted that application, first one in 2022. When my no action was taken, then again I filed the another representation.
Page number?
My lord?
Page number?
Page number 25. This is a second reminder. Because well, they are keeping the things pending for a long time. So whereby, my lord, I have stated, my lord.
Person is Annexure 2, page 24.
Yes, first was Annexure 24, and Annexure 2 at page 24 for affiliation. I prayed there to NOC, my lord, affiliation may be issued in my favor. When there not action was taken, then second was filed. Where, my lord, I specifically mentioned, with due respect to inform you that we are applicant for NOC as well as the affiliation to get the approval from the BCI from running LLB, BA LLB honors course by letter number such and such. Accordingly, applications are received by affiliation branch through the registrar office, but branch did not proceed the applications for NOC as per as the affiliation in the sanction EC meeting will be held regarding the state NOC is required or not in new for new colleges, including the law colleges. In these circumstances, I have honored to inform you that as per the UGC affiliation of college by universities, regulation 2009 stated NOC does not require for the LLB or BLLB honors course for affiliation. Aforesaid regulation under section 3, subsection 3(1) stated that the requirements in respect of the any of the them prescribed by the statutory regulatory body concerned, whichever is higher. Well, after informing as per the BCI inspection manual 2010, stated NOC does not require for the new colleges or private colleges. Aforesaid manual chapter 2, paragraph 6 stated that in case of the state funding institutions or institutions seeking fund from the state union government as statement from the relevant government for no objection to the applicant or as a specific preliminary approval or sanction for the establishment of a new institution. Well, here it is specifically stated that only in case of the government-owned funding or they government-owned colleges. But in case of the private institution or private colleges who are not claiming any minor assistance from the government, purely private, the NOC is not required. So I don't know, my lord, why universities so vehemently objected these things. My lord, that will not harm anybody, my lord, because I am not giving any burden to anybody, because this is my burden. I am running the college in my own source, I am able to give the salaries to the all the persons to will be appointed from my own source. The liability will not come to the government. Then where is the objection, my lord, to getting the honesty? So it's BCI also saying that there is no required from the in case of the private college, and their UGC
Whether
regulation also.
BCI submitted, filed their affidavit.
No, they are stating, my lord, they are not going to file any affidavit, my lord.
So who is the counsel?
My lord, the Pritam Mahanta,
So-
he was there.
You will file.
Fine.
When?
No, but the earlier occasion, her senior stated in court that they are not filing any affidavit, my lord. Probably that was recorded also. If I go through the order, well, I will find out, my lord.
No, you were submitting on the basis.
But
of
from the record there-
statement Or on, of your own, you have submitted that you will file a objection. You have instruction. You have instruction. Mr. Kokano, what is your stand?
Milord,
You have filed affidavit?
They filed. I reply
Milord,
also.
there are two crucial aspects, Milord. My learned friend missed, Milord. One, it is not only LLB course, it's a BA LLB course. And this BA course comes under the Directorate of Higher Education. Assam. So, as regards BA course, BCI has got no role to play. So, the NOC from government. It
Is
the
required.
Milord.
That is
Then-
your stand.
Yes, Milord. And second one, Milord, if we turn to page 36 of the writ petition, I only point out 2-3 lines, Milord. The first 2 lines. New institution seeking approval for its affiliation with a university and proposing to establish and run a law school.
You
or a
you
course.
were reading clause
Page-
number?
Page 36, first 2 lines.
Yes.
Clause 1.
Yes.
Second line particularly, proposing to establish and run a law school or course in law, not regarding that BA course. If one institution or university proposes to run a law course, then this BCI manual would be applicable. And the next one, clause 6. I'll read the entire paragraph. In case of state-funded institutions or institutions seeking funds from the state union government, a statement from the relevant government for no objection to the application or a specific preliminary approval or sanction for the establishment of the institution. Now it is important. University faculty department would, however, not require the same, but has to submit the resolutions from various authorities required for the establishment, which shall also be accompanied by act, rules and regulations of the university. Now, kindly turn to next page, Milord. Page 37, clause 6. Next page, Milord. Copies of the affiliation letter, if it is an affiliated institution from the university, NOC from the relevant government, if it is a state-owned or funded institution, must be submitted with the application. So, Milord, this BCI manual is regarding state-funded institution. But if it is a privately run institution, then what happened? Milord, the Guwahati University has not been barred from setting a standard, from following the government office memorandum for obtaining NOC by a private institution. It's a minimum requirement of the BCI manual. And the Supreme Court is clear, Milord. If it is not barred by law, then, Milord, the authorities can, Milord, go through any, Milord, directions or resolutions, Milord. And the EC resolution is clear that office memorandum of 2019 would be applicable as regards private institutions. And the government affidavit in paragraph 5 and 6, particularly paragraph 6, is clear that NOC office memorandum is applicable to private run institutions. So these two crucial aspects, Milord, my learned friend, Milord, missed about that. That BA course and whether the law.
Mr. Mohanto, BA course cannot be postgraduate course.
My lord, here,
LLB 3 years after graduation, that is all right.
no, my lord, one thing, my lord. My learned friend is, my lord, again, I am repeating these things, my lord. He, page number 37, where it is, my lord, he is emphasizing only one thing, that in the case of the private college, my lord, the NOC is, my lord, required. But here it is saying, the copies of the affiliation letter, if it is an affiliated institutions from the university, then, my lord, NOC from the relevant government, if it is a state-owned or funded institution, my lord. So NOC is specifically stated, if it is a state funding or state-owned institution, then only NOC, not in the case of the private institution, my lord. And he's trying to emphasize that this guidelines is purely for the, my lord, affiliated, my lord, the government institution, whatever is, my lord, it is stated, not for the private. But it is private, it is specifically mentioned, NOC for the relevant government, if it is state-owned or funded institutions, my lord. That means what it is saying in negative, my lord. If it is not funded institution, NOC is not required. It is, my lord, clear presumption. There is nothing doubt, anything. And moreover, my lord, he is insisting one thing, my lord. He is saying that is so far the LLB 3 years course is there. My lord, the NOC is not required. His own submission. And in case of the BA LLB, as there is a BA, so this is a, my lord, the comes under the university. Then, my lord, I am admitting these things as I assuming, if it is, my lord, then that what is the bar in allowing me the 3 years LLB course without NOC? Because I am specifically stated there is a LLB 3 years and also, my lord, 5 years integrated. So at this stage, at least, my lord, 3 years they should allow us for affiliation. Why they are not insisting on giving this affiliation? Rather, they are insisting me that you should get the NOC from the government.
My lord, some words have been put into my mouth, my lord. My lord, there are two parts. One, BA course.
BA LLB.
BA
The other is LLB 3
LLB.
years degree course.
Regarding BA part, the Director of Higher Education's role would be, my lord, applicable, my lord. It will be item. Regarding LLB course, my lord, this BCI manual is regarding state-funded institution, not private-funded institution. And we can set the standard, my lord. We have got that discretion, my lord. The Guwahati University Act, my lord, amplifies that, my lord, power. And if, my lord, the statute or law does not bar, then, my lord, we can set that standard, my lord, that little bit higher standard, that NOC would be required for privately run institutions regarding that LLB course.
My lord, my learned friend is saying that it is a no bar. It is a bar, my lord. In their own regulation, it is bar. UGC regulation, my lord. It is specifically stated in UGC regulation. Lordship, I can provide to Lordship the regulation, my lord.
Okay. Okay, but we will resume after 5 minutes.
Right.
Yes.
My lord, the UGC affiliation regulation, my lord, 2009. It is, my lord, clause 2.6 and 3.1, my lord. This Lordship have to go first 3.1, my lord. First 3.1, my lord. It is specifically stated as statutory regulatory body, and statutory regulatory body also defined in 2.6. So, my lord, their own regulation, it is specifically stated that in case of the, my lord, the BA, this is LLB course, that will come under the, my lord, BCI, and this is the statutory regulatory body, and whichever is higher, my lord, in case of the conflict between the two, the state, my lord, this is Guwahati University statute, and the, my lord, BCI will prevail, my lord. It is a statutory law, my lord. It is a established law. They cannot say that, but they are above the BCI. And moreover, my lord, he stated that, my lord, BA LLB. My lord, Lordship, I annex the, my lord, their own regulation on the basis of which, my lord, they have refused to give the NOC. This is at page 27. This is the state government. It is only to prevent the mushroom growth institutions after the enactment of the Assam Education Provincialization Regulation, Provincialization Service of the Teachers and the Reorganization of the Education Institution Act 2017. So it is specifically stated where the definition of degree college means it page 27, Lordship. Clause Roman 4, degree college means a college imparting general education for 3-year degree courses in arts, science, and commerce. But here is a 5 years law course. It is purely professional course. It not neither come under the arts, science, and commerce, my lord. So this regulation, the OM also not applicable to me. It is specifically stated a 3 years course. So BLLB, if it is completed 3 years, he will not get the certificate of BLLB. An LLB course is a purely a professional course. This is neither comes under the arts, science, and commerce. So near nowhere it is.
Mr. Monto, your submission might be correct in respect of 3 years degree course.
No, my lord, the 5 years, my lord, the degree course, it is a 5 years.
No, that's all right. That course is BA LLB course.
Yes, my lord. But this is, my lord, the curriculum has been fixed by the BCI. The entire course has been, my lord, fixed by the BCI, not by the UGC, by the Guwahati University. The entire curriculum is, my lord, conducted by the BCI. What will be the curriculum for the 5 years course? Only the mention is that the BA LLB. That means, but after getting the BA, or if you go for the BA LLB, my lord, this is another 3 course. So reducing the one year cut, my lord, is now making the 5 years. It is integrated, my lord. So in that aspect, they cannot say, they cannot bifurcate the both courses, my lord. It is either come in the particular one authority, not come under it. Otherwise, that will be chaos. That is why, my lord, this specifically they have UGC regulation, my lord, is specifically stated. This date will come under the regulatory authority statute, whatever is higher. So my case, my lord, regulatory authority also they are defined. Who are the regulatory authority? The BCI also the one of the regulatory authority. So BCI is definitely, my lord, the higher than the Guwahati University statute. So my humble prayer is, my lord, whatever they are insisting to get the NOC from the government, so far the my institution concerned, this is not applicable in my case. Because, my lord, the BCI regulation saying the same thing, that in case of this state-owned, state-funding institution, the appellation, my lord, the NOC for getting the affiliation university is concerned is required. But in case of the private institution, this is not required. And the BCI also saying that in case of the private institution, NOC is not required. It is, my lord, I have annexed the document, my lord, lordship, again, I am gave some little trouble to your lordship to go again, my lord, page 36 and 37. It is specifically stated, but it is, my lord, initial approval, instruction with application for initial approval under the head of this thing, my lord. The clause 6, in case of a state-funded institutions, it is specifically stated, the state-funded institutions or the institutions seeking fund from the state, union, government, a statement from relevant government for no objection to the application or as a specific preliminary approval or sanction for the establishment of the institutions. University faculty department would, however, not require the same, but has to submit the resolution from the various authorities required for the establishment of which shall also be accompanied by the act, rules and regulation of the universities. But in case of the universities, they did not come under me. I am not come under that university, but I am an institution, private institution. My institution is not a university, my lord. And second, my lord, this second next page, why it is required and why it is mandatory, it is specifically, my lord, periodic inspection under the head, my lord, it is specifically stated in clause 6, again page 37, where the copies of the affiliation letter, if it is an affiliated institution from the university, NOC from the relevant government, if it is a state-owned or funded institution, must be submitted with the application. So in my case, my lord, I am totally is a private, so not a state funding or neither state funding nor state-owned institution, my lord. So this is specifically BCI is very clear in which case the NOC is required. So my humble submission, my lord, my institution is purely private institution. I specifically admitted in my writ petition also, and not only the first institution, in this institution like that I opening or I am running, going to open. Already, my lord, 6 institution I have already running. Not only that, my lord, this pharmacy education also I am providing. I mean, a BLA, LLB, BLA, B.Ed institution also I am running. Well, another institution also I am running. All are private. No NOC is required. But in case of the BCI, this for going to whenever starting a LLB course, now their university is totally keeping the things up for a long time without considering, insisting on relying on this OM. OM cannot be override the statute, my lord. This is a established law. So how the OM will override? And OM also not specifically stating that in the case of the 5 years course or 5-year degree course, what will be the procedure? They are specifically stated in case of the 3-year degree course, that is arts, science, and commerce. My institution neither follow any of the category.
So, Mr. Monto, you tell me, who is that there is order of this court that BCI will not file their affidavit?
Well, there is my learned friend, my lord, he submitted on the, probably I forget the code, my lord. I insisting on him that to file an affidavit. Then code he submitted that they were not filing the affidavit, they are not going.
Who is that?
Russia will receive instructions from BCI.
Now they are at a long gap now.
They will file affidavit. So when you are going to file it?
My lord.
2 days. No.
My lord, one order maybe, my lord.
Matter is pending since the year 2022.
My lord, the urgency is there. That is why we approached the Supreme Court also, my lord.
Pardon? No.
I fixed a date, my lord. On that date, that may be disposal, because, my lord, we approached the Supreme Court also. Matter is keeping pending for a long time for different reasons, my lord. Not for the fault of the court, my lord. This is part of the advocate parts, my lord. So we have to compel to go to the Supreme Court for a direction so that matter will be expeditiously hard and disposal. So my prayer, my lord, the lordship, it is allowed, then my lord, the specific time should be given so that by this time they
So
should.
1 week time, we keep the matter as further.
Yes, my lord.
Only for your affidavit.
Yes, my lord. That will be better, my lord.
Third, Mr. P. Monto, learned counsel for the petitioner, and Mr. P. learned standing counsel for the respondent number 2. Respondent number 2, and Mr. Puya for respondent number 1. Then, Madam, your good name, please. M. Borgomai, learned counsel for the respondent number 4. Mr. Tesoma for respondent number 3, UGC. Hardin part, list the matter on COVID. 1 week. 8 May.
There was also on 13th May possible. 13th May, Tuesday. Come case. 13th May. 13th
long
Tuesday.
date. That will be the
8 May. Okay. 8 May. In the meantime, the learned standing counsel for the respondent number 4 may file affidavit in opposition if so advised.
Milord, can it be on 13th, on 8?
You have
some
difficulty.
problem.
Okay, my lord. I consider, my lord.
13. Okay, 13.
I consider, my lord, his request.
No, Mr. Pukano, why there is bar in granting this 3 years course?
Milord.
In respect of 3 years course?
Milord, regarding that BCI manual, Milord. Milord, this Bar Council of India rules is also clear, Milord. State government's no objection certificate is required under Rule 16(6), Milord. This Bar Council of India rules.
Now, as per that office memorandum of the government.
Milord, it is Milord with effect from 2008. This Bar Council of India rules. And this office memorandum has been passed in 2019.
2019.
And the EC resolution of the Guwahati University has been passed in 2022. So whether we can set the little bit higher standard in tune with the Bar Council of India rules, that should be looked into. Yeah.
For hearing, I think 17 and 18.
May I please, Lordship? So this is a small issue, Lordship. Whether, Lordship, the petitioner, what will be the effective date of getting the UGC scale of pay? Also, I was given the UGC scale of pay from August 2009, but I am entitled from 12/11/1993, that is from the date of regulation. Why, Lordship?
Date of regularization.
Lordship, at the relevant point of time, Lordship, may kindly see, Lordship, I was initially appointed in terms of a judgment at page 16. And the relevant portion at page 20. Page 20 may, Lordship, and that UGC notification, UGC guidelines has been Lordship, incorporated there, Lordship. Your Lordship may kindly see page 20, paragraph 7. A candidate not holding an 7 Roman 3, Lordship. Page 20. A candidate not holding an MPhil but possessing a second-class master degree should have obtained a first class in the first degree, BA, BSc, BCom exam. High second class is determined 52.5 in the master's degree. Lordship, I had 52.9% in my master's degree. 52.90. So, Lordship, MPhil was in fact not required at that relevant point of time. This 55% norms came only in the year 2010. The UGC revised notification, Lordship. Then your Lordship may kindly see my appointment, Lordship, at page 22. In inviting a reference to the letter cited above, I am directed to say that an additional post of lecturer in the Department of Hindi has been sanctioned to your college to regularize the service of Wahiduzzaman as lecturer in the Hindi department with effect from 12/11/1993 as per government instruction and at Honorable High Court's order in the following terms and conditions. There is a condition, Lordship, that he should have at Lordship, 1, 2, 3 clause are there. Wahiduzzaman is allowed to draw the fixed UGC scale of pay 220.
Page number, you are referring to page number?
Page 22.
22.
Lordship.
Yes.
He is given a fixed UGC scale, then he will have to obtain MPhil or PhD degree within 8 years from the date of approval of his appointment. Lordship, this condition also I fulfilled in 2009. Lordship, then may kindly turn to page 24, office order. On fulfillment of terms and conditions mentioned in this office order dated so and so in respect of Muhammad Wahiduzzaman, Assistant Professor in the Department of Hindi of ADP College, Nagaon, District Nagaon, regular UGC scale of pay is allowed with effect from August 2009 with date of next increment on 1/7/2010 as Muhammad Wahiduzzaman has obtained MPhil degree on August 2009. So I was given the scale of regular scale, Lordship, from August 2009 since I had passed obtained my MPhil degree. But Lordship,
August 2009.
August 2009.
So you have passed MPhil.
MPhil.
Okay.
This order is of 16/9/2011. Page 24. This is a typed copy, Lordship. Original.
And from this date you were entitled to.
They have said that I am entitled from August 2009.
And as per your
Lordship, I am entitled from my date of regularization. That is Lordship 12/11/1993.
Pardon?
From my date of my 12/11/1993, I am entitled, Lordship.
12?
12/11/1993.
Okay.
Thereafter, I filed a representation lawsuit at page 25. At page 28, lawsuit director also wrote to the government for reconsideration of the date of effective for approval of appointment of the petitioner lawsuit. At page 28. Lawsuit, may I read this letter?
Page 28.
Page 28. In inviting a reference to the subject cited above, I have the honor to forward herewith a proposal received from the principal ADP College, Nagaon, in connection with reconsideration of date of effect in respect of Mohammad Wahiduzzaman, assistant professor in the Department of Hindi. He was appointed by the college authority against non-sanctioned post during 1985. His post was not approved as he has honors in political science in degree level, which was also co-relation on the subject Hindi. On the basis of the Guwahati High Court judgment, in CR number 30488, his post was approved and regularized his service with effect from 12/11/1993 in fixed UGC scale of pay at the rate of 4,000 per month, plus other allowances as admissible under rules and provisions with condition that he will have to obtain MPhil or PhD degree with 8 years from the date of approval of his appointment. He was not eligible to draw senior selection grade scale of pay until he fulfills the conditions laid down in the letter. In the meantime, Mohammad Wahiduzzaman obtained the MPhil degree and was allowed to draw regular UGC scale of pay with effect from August 2009. Now, Mohammad Wahiduzzaman claims that some similar cases have been considered by the government of Assam and allowed regular scale of pay from the date of joining, and claims that he is entitled to get the benefit of regular UGC scale of pay with effect from 12/11/1993, that is from the date of joining against sanctioned post. This is for favor of your information. Now, also I have given the many citations of other assistant professors who have been given in same
Similar benefit.
in same city. At page 29, also this is the first order. Also, may kindly see. This is in respect of Arpana Tamuli. On fulfillment of terms and conditions mentioned in the office order dated so and so in respect of Sri Arpana Tamuli, lecturer in the Department of Philosophy of Rupohi College, Rupohi District, Nagaon. Regular UGC scale of pay rupees 8,000, 13,500 PM is per month is allowed with effect from 11/1/1996 with date of next increment on 1/1/1997, as Srimati Arpana Tamuli has obtained MPhil degree on September 2010. She has also obtained MPhil degree in 2010, but she has been given the regular from the back date, that is 11/1/1996. Same situation here also. This is the approval of the Government of Assam Higher Education Department, letter dated so and so. This is subject to cancellation modification without prior notice. This is an order issued by the director also. This Arpana Tamuli has been given regular UGC scale before obtaining her MPhil degree. She has obtained it in 2010, but she was given retrospectively from 1996, that is from the date of regularization. My case is exactly similar also. Then Lordship may kindly see page 30. Several assistant professors I have given citations also. This is a speaking order issued by the Higher Education Department in respect of one Pratibha Chaudhary. In pursuance of the Honorable High Court's order dated 4/10/2010 passed in WPC 2603/2012, Pratibha Chaudhary, a hearing had been conducted on 1/2/2014 in the office chamber of the Commissioner and Secretary to the Government of Assam Higher Education Department on regularization of services of Pratibha Chaudhary by allowing to draw regular UGC scale of pay and all consequential benefits with effect from 11/1/2016. Then, Lordship, the government in the Higher Education Department made approval for regularization of the services of Abdul Jabbar Ali Ahmed, lecturer in economics, Srimati Nibharani Das, lecturer in Assamese of Borpeta Girls College, Borpeta, by government letter dated 35/2000. Both the lecturers have been allowed the regular UGC scale of pay with effect from 25/5/1998 with deed and UGC norms of 52.5% in MA degree. Since Nivarani Das joined in the service on 24/10/87 with relaxed norms of 47.5% in the literature subject in MA degree by letter dated 7/12/1987. So they have admitted, Lordship, that at the relevant point of time, the UGC norms was 52.5%, and I had also 52.90% before obtaining my MPhil degree in 2009. So I should have been also given that regular UGC scale from my date of regularization, from the date of appointment or in the sanction post. Then Pratibha Chaudhary, who has also been serving in the Mandya Anshalik College as lecturer in Assamese with effect from 27/10/1987, securing 50.12% in MA degree, much below. As such, Srimati Pratibha Chaudhary fulfilled the requisite qualification for the post of lecturer at the time of her initial appointment as per government letter dated 1987. She approached to government for regularization of her service, allowing UGC pay scale with effect from 11/1/1996. The DAC has stated that in response to the government letter dated so and so, 175 number of lecturers working against sanction posts in different deficit grants in 8 colleges in the state scale of pay in fixed UGC pay scale with the condition of obtaining MPhil PhD degree for incremental benefit. The name Srimati Pratibha Chaudhary was at serial number 17 of the list for UGC fixed pay of rupees 2,200. But no plausible statement was available from DAC as to why her case had not been examined in light of the letter dated so and so, and therefore the question of inclusion of her name in the above list cannot relate to the case. Dr. Guninder Das, Principal, Borpeta Girls College, Borpeta, the IC Principal, Mandya Anshalik College, Mandya, Borpeta, Sri Pratibha Chaudhary, lecturer in Assamese, Mandya Anshalik College, Mandya, had submitted the written statement and their documents regarding the case. After observing and examining the documents particularly relating to Pratibha Chaudhary case, that she was deprived and prove her claim. Hence, on the stand of hearing conducted on so and so, it will be prudent to initiate action for regulation of services of Pratibha Chaudhary by allowing to draw regular UGC scale of pay with all conjugal benefits with effect from 11/1/1996 on the basis of the letter dated 7/12/1897. These are the citations I have given, Lordship. Thereafter, Lordship, a speaking order was passed in respect of. Lordship, I have also annexed the writ petition filed by Pratibha Chaudhary at page 35. And this writ petitioner in terms of the Honorable High Court's order, Lordship, Pratibha Chaudhary, Lordship, she was given the UGC scale from 11/1/1996 at page 38. 38A is the original copy. Page 38 is the type copy. Then this writ petitioner, Lordship, he has again approached before this Honorable Court by way of filing a writ petition 1716/2014 at page 39. This writ petition was disposed of by remanding the matter before the Commissioner and Secretary, Lordship, at page 41, Lordship. Lordship, I am reading the last paragraph. The writ petitioner was compelled to approach this court as his representation dated 25/10/2011, which was taken on record by the Director Higher Education and was forwarded to the Commissioner and Secretary Education Higher to the Government of Assam by this letter dated 5/4/2013 was not disposed of. Having heard the Land Council for the parties and has agreed to by them, this consent order is passed disposing of the writ petition directing the Commissioner and Secretary to the Government of Assam Education Higher Department to take a decision in the matter as brought to this notice by letter dated 5/4/2013, referred to herein above within a period of 6 weeks from today. The petitioner may produce a certified copy. Lordship, this matter was disposed of, remanded back the matter to the Commissioner and Secretary. Thereafter, Lordship, when nothing was done, I had to file a contempt case also at page 43. Only during the pendency of the contempt case, Lordship, page 43 and page 44. The order is at page 44, Lordship. That in now, Lordship, that impugn order which I have to challenge at page 45. This order has been passed. 8 February 2017, Lordship. Page 45. May I read the order, Lordship? Page 45. Lordship.
So this order is being challenged in the other petition also, yes? You are
No,
agreeing?
no, that is only because of the order
Hearing
passed
this
in this,
matter, Lordship.
only because of the order passed in this court. Why you have given benefit to other teachers? This Arpana Tambole, SOCOS was issued to her. Thereafter, she was given the area payment, Lordship. That is how this honorable court passed an order. Why you have given similar benefit to other lecturers, but not to me. That is why, Lordship, she was put to SOCOS and she
Lordship,
was
may I
given.
have a look at the order passed by this court on 11/1/2024, Lordship. 11/1/2024, Lordship.
Page number?
Lordship, it is an order of this court, Lordship.
Order
This
of
matter
this
only.
court.
Yes, Lordship. Passed by coordinate bench of this.
Lordship, I'll try to explain, Lordship, everything.
11/1/2024, Lordship. Lordship, the Aparna Talukdar, Lordship, similar. Eleven one 2024.
Lordship, I will not take much time, Lordship. I will, within 10-15 minutes, Lordship, I will
Okay,
complete. Lordship.
let him complete.
Lordship, because Lordship, this matter is under process in the department, Lordship, and the department this morning has given me an instruction seeking 2 weeks' time to file a detailed affidavit in the other case also, Deva Mallika, Lordship, so that this matter can be disposed of in the final stage of hearing, Lordship. So that matter is of 2024. It has been tagged along with this matter, Lordship. So, Lordship, we have taken step for recovery to the.
No, are you entitled to recover?
Lordship, I have no objection to the prayer made by my learned friend, Lordship, in the other item, Lordship.
Otherwise, Lordship, in this matter also, he is not eligible, Lordship. Even in 2009, which he got, Lordship, it is by mistake, Lordship, because he is not entitled, Lordship. There was a condition for him to fulfill MPhil within 8 years. But Lordship, he has done his MPhil only in 2009, Lordship. So that also we have given it wrongly, Lordship. He shouldn't have been entitled to get since 2009 also, Lordship. So, Lordship, let that affidavit also come, Lordship, and this matter may be taken up for final disposal, Lordship.
No, then why you remain silent since the beginning of his argument? We could have adjourned the matter at the earliest.
Yes, Lordship. Apologies, Lordship, on that. For that, Lordship, sincere apology, Lordship. But I have placed the instruction, Lordship, which I have received this morning also. Only, Lordship, I have placed this. I placed the instruction, Lordship.
Yeah, what to do? Whether their affidavit is required or we can dispose of the matter.
Lordship, my learned friend will get the benefit of, Lordship, the judgment. But Arpana Tambole, she will not get the benefit because there is a rider. Because initially, Lordship, she was put to SOCOS. The commissioner, Lordship, by this impugn order, Lordship, by the same impugn order, Lordship, it has been mentioned, SOCOS, Director of Higher Education Assam has issued SOCOS notice to Arpana Tambole, lecturer of ADP Nagaon, who has been allowed regularization benefit from the date of joining, although she acquired MPhil in 2010.
No, who had granted the benefit to Arpana Tambole?
Yes. Then, Lordship, in 2017, she was given the entire area, Lordship, at page 48, sanction of areas in respect of Arpana Tambole. This is subsequent to, Lordship, the order passed by the impugn order, Lordship, at page 45. This in page 48, Lordship, this 27 March 2017. The Arpana Tambole was sanctioned area seller of amounting rupees to 14 lakhs 98 8,287. Same authority law. So she will not get the benefit of the judgment. That retired person cannot make recovery. Now, if he wants to file an affidavit, also already there are orders passed by the honorable court that lordship may kindly see. One order has been passed by this honorable court. At lordship on 21/3/2024, the honorable court has passed an order. Lordship may kindly see that order. 21/3/2024. The Secretary to the Government of Assam, Department of Secondary Education, has filed an affidavit on 15/3/2024 in pursuance to the undertaking as given by him before this court on his personal appearance on 25/1/2024. On perusal of the said affidavit, it is seen that the undertaking as given was not complied with. Further, the said affidavit brings on record a communication from the Director of Higher Education Assam dated 16/2/2024, wherein the Director of Higher Education Assam has opined that the recovery of the payments illegally held to be paid to the persons mentioned therein cannot be recovered, referring to the case of State of Punjab and others versus Rafiq Masi. There is a stipulation in the order dated 8/2/2017 issued by the Commissioner and Secretary to the Government of Assam Higher Education Department that proceedings have been initiated against one Arpana Tambole, lecturer ADP College Nagaon, who was allowed the regularization benefits from the date of her joining. Although she had acquired MPhil qualification in 2010, the said stipulation as made in the order dated 8/2/2017 clearly reflects that the authorities were alive to the fact that payments as made to the said persons were so made without any authority. However, the payments so made have not been recovered. Rather, after passing of the order dated 8/2/2017, on 27/3/2017, the areas that would be available in the matter was duly released to the said person, ignoring the stipulations as contained in the order dated 8/2/2017. Your lordship has seen both the orders, lordship. The imping order at 8/2/17 and subsequently the area sanction on 27/3/2017. This has been lordship reflected in the orders. Mr. K. Gogoi, Land Standing Council for the Higher Education Department submits that he be given 10 days time to take remedial actions in the matter. As a last chance, Mr. Gogoi, Land Standing Council is granted 10 days time to take remedial actions in the matter and withdrawal of the letter dated 16/2/2024. In the event the remedial action, which would be nothing less than the recovery of the amounts illegally stated to have been paid to the persons mentioned in the communication dated 16/2/2024, is not recovered or steps for such recovery is not initiated, this court would be left with no other alternative but to allow similar benefits to the petitioner and or proceed against the officers who have facilitated such release of illegal benefits to the persons mentioned in the communication dated 16/2/2024. So, lordship, other persons have been given the benefit, lordship. I have been left out, lordship. And lordship, in fact, lordship, I had the UGC norms of 52.90% at the time of my regularization. That MPhil was not required. In this regard, lordship, I am paying for similarity of treatment, lordship. Two small judgment I have got, lordship. One from this honorable court and another Supreme Court. Similarity of treatment, lordship.
Yes.
May I please it? One is Ramesh Goswami, lordship. This is a division bench order. But I am relying upon paragraph 15 and 17, lordship. May I read paragraph 15, lordship? The appellant has alleged discrimination on the part of the state respondents, thus infringing his right to equality under Article 14 of the Constitution of India. In this context, we feel impelled to refer to the observations of the Apex Court in a recent decisions reported in 2002-4 SSC 34. Ashutosh Gupta, appellant versus State of Rajasthan and others. Respondents, we extract herein the relevant portion of the judgment. The concept of equality before law does not involve the idea of absolute equality amongst all, which may be a physical impossibility. All that Article 14 guarantees is the similarity of treatment and not identical treatment. The protection of equal laws does not mean that all laws must be uniform. Equality before the law means that among equals, the law should be equal and should be equally administered, and that the like should be treated alike. Equality before the law does not mean that things which are different shall be treated as though they were the same. It is true that Article 14 enjoins that the people similarly situated should be treated similarly, but what amount of dissimilarity would make the people disentitled to be treated equally is rather a vexed question. Mere differentiation or inequality of treatment does not per se amount to discrimination within the inhibition of the Equal Protection Clause. The state has always the power to make classification on the basis of a rational distinction relevant to the particular subject to be dealt with. In order to pass the test of permissible classification, two conditions must be fulfilled, namely that the classification must be founded on an intelligible differentia, which distinguishes persons or things that are grouped together from others who are left out of the group, and that differentia must have a rational relation to the object sought to be achieved. Then your lordship can make skip paragraph 16. Then 17 lordship. The plea on discrimination taken on behalf of the appellant can be said to be lordship. And this has, I have also given the Supreme Court decision, Asutosh Gupta, same lordship, that has been quoted lordship, paragraph 5 and 6.
This was quoted.
Quoted lordship. Paragraph 5 and 6. And it is apparent lordship, all the other similarly situated assistant professors have been given the benefit. And I had acquired 52.9%. At that time, lordship, MPhil was not required. But I was denied the regular UGC scale. I was given UGC fixed pay. This is my submission, Lord.
Second matter, perhaps it is slightly different. I am not Aparna Tamuli. I am Dr. Devi Malika Raskwa. I had retired as a professor, associate professor in of DHSK College, Dibrugarh in 2016 itself. I was given pay protection in 1987 itself, Your Lordship. And no show cause notice was ever issued to me. But after the order passed in the other matter, a communication was addressed by the Director of Higher Education to the principal of the college, which Your Lordship will find at page number 68, the second petition.
Page number
68, Your Lordship. With reference to the subject cited above, I have the honor to inform you that in compliance of Honorable High Court order dated 11/1/2024 and 21/3/2024 in WPC number 4151/2017, so-and-so, the access drawal granted to Miss so-and-so, I am number B, Miss Malika Devi Raskwa, DHSK Commerce College, is to be recovered as per law. Therefore, you are requested to take necessary action to recover the excess drawal from the dearness relief or provisional pension of the above recovered incumbents, if pension is not yet finalized, and take steps to submit the excess amount in form number 19, so that the entire amount can be recovered from DCRG if PPO/GPO is not issued by the Accountant General Assam. In case pension is finalized, matter should be communicated to the concerned Treasury Officer to take necessary action as directed by the Honorable Court. Now, pursuant to this, Your Lordship, a communication was addressed to me by the principal of the college, which Your Lordship will find at page number 60, page number 70, Your Lordship. Madam, with reference to the subject letter cited above, I would like to inform you that as per the Honorable High Court order dated so-and-so and so-and-so, the excess drawal is to be recovered from your DR, and the undersigned is directed to communicate the matter to the Treasury Officer for necessary action. Now, Lordship may kindly see there was no direction from the Honorable Court to recover. What the court, before coming to the merits, what the court has said that if it has not been recovered, then similar benefits will be granted to him. Now, after that order is passed, this communication is issued. Now, this is completely in the teeth of the judgment passed by the Honorable Supreme Court in Rafiq Masih. I have retired in 2016. Lordship may have my pension order, which is at page number 62. My pension order is there. Lordship will see page number 63, the first page. The pension, I have been receiving pension from 1/1 to 1/10/2016, Your Lordship. Now, almost 8 years after my retirement, they are trying to initiate recovery proceedings against me, and no show cause is issued to me. I do not know how Miss Arpana Tamuli stands, but for me, apart from this communication received at page number 68, prior to that, there was no communication. And I had completed my MPhil in the year 1991 itself, Your Lord. And I have been receiving pay protection from 1987 at the UGC scale of pay. Now, if Your Lordship has the judgment of the Honorable Apex Court in Rafiq Masih, there is no scope for any recovery after retirement.
Which is the relevant paragraph?
Paragraph number 18, Your Lordship. It is not possible to postulate all situations of hardship which could govern employees on the issue of recovery, where payments have mistakenly been made by the employer in excess of their entitlement. Be that as it may, based on the decisions referred to herein above, we may as a ready reference summarize the following few situations where recoveries by the employers would be impermissible in law. Number 1 is for group class 3 and class 4 employees. I am not in that. Number 2, recovery from retired employees or the employees who are due to retire within 1 year of the order of recovery. I have retired in 2016 itself, Your Lord.
So you are covered by this.
I am covered by this. So even I am saying I have been rightly given. But for the sake of argument, if we say that it has been given by mistake, even then now recoveries are not permissible, Your Lordship. So that is why I am challenging this order. And the very foundation of the order that this has been done pursuant to directions passed by the Honorable Court, perhaps that is erroneous, Your Lordship. If Your Lordship has the order of this Honorable Court, at page numbers, it starts at page number 79, the relevant portion is at 80. This is what they have referred to as a direction. The last paragraph. In the event, the remedial action, which should be nothing less than the recovery of the amounts illegally stated to be paid to the persons mentioned in the communication dated 16/2/2024, is not recovered or steps for such recovery is not initiated, this court would be left with no other alternative but to allow similar benefits to the petitioner, that is the petitioner in item number 17. So there is no direction to violate the law laid down by the Honorable Apex Court. What the court has said that if you have not done it in accordance with law, then he will be entitled to a benefit. But that cannot be construed as a direction to the authorities to violate the law laid by the Apex Court and initiate recovery proceedings, Your Lord. So my submission is that the order dated under challenge, the communication at page number 80, 68, communication at page number 68, that is bad in law, Your Lordship. It needs to be set aside.
So this is the impugn communication.
Yes, 1st of April 2024.
Then next is 60.
Yes, those are consequential communications issued pursuant to this.
70.
Yes, 69 and 70.
So why affidavit is required?
Lordship, in this matter, Lordship, since there was an order of the court that what action we have taken, even if we have stated that these are wrongly given to one Aparna Tamuli, Lordship. So what remedial action we have taken? So Lordship, that's why we have taken those action, Lordship, in this matter, Lordship.
No, in view of the judgment of Supreme Court in the Rafiq Masih case, can you entitle to recover the amount?
Perhaps, Lordship, in this matter, no, Lordship. But Lordship, otherwise, in the item number 17, Lordship, that he is claiming benefit of the as given to the other petitioners, Lordship, Aparna Tamuli and others, Lordship. But he cannot claim that, Lordship, because those already we have given it wrongly to one person. He cannot claim similar benefit. One wrong, Lordship, cannot be given to another, Lordship. Subsequent wrong cannot be done, Lordship. Since we have done it.
Then in that matter also you have filed your affidavit?
Lordship, we have not filed a detailed affidavit, Lordship. We have only filed the affidavit stating the communication, Lordship, of the Lordship, subsequent communication of the Director of Higher Education, Lordship. Because, Lordship, since there was a stay, Lordship, in this order, Lordship, Deva Mallika, Lordship. So, Lordship, we have not done anything after the court's order, Lordship.
Pardon?
Lordship says there is a stay operating, Lordship, in this, the item number 18, Lordship.
Yeah.
So, Lordship, the matter is now, Lordship, hanging, Lordship. Because we have taken step, then the petitioner in item number 18 approached this court lordship and there is a.
No, why should we keep the matter pending then? What is to be decided here in this petition?
Lordship,
it is
in
there,
item
it-
18 or 17
It
lordship?
is
18.
there, Lordship, the
Lordship,
department has taken a
18
stand.
lordship,
Lordship, I have not,
Perhaps,
in my
Lordship-
writ petition, Lordship, I have never
No,
said
no,
that.
please, please.
Lordship,
in 18
In
lordship,
item number 18.
yes, lordship, 18,
So law is well settled by
Yes,
Supreme
Lordship.
Court.
in
So
18
your
lordship,
affidavit will not change the legal proposition.
yes, lordship. In 18 lordship, I do not have much to say, lordship, but in 17 lordship,
Yeah.
I may be allowed 2 weeks time so that everything, lordship, since this matter is pending in the government lordship, so I will file a detailed affidavit, lordship, and a fixed date may be given, lordship, I will file a affidavit before that day, and it can be taken up for final disposal, lordship, in item 17, lordship. 18 lordship, I do not have anything to submit, lordship, much.
So 18 we are disposing of.
Okay.
Lordship, in my writ petition, Lordship, I have never claimed, Lordship, that the similarly situated assistant professors, they have been given illegal benefits. It is their stand, Lordship, that they have been illegally given. When I have approached this honorable court seeking similar benefit, it is their stand, Lordship, that they have been illegally given. Lordship, I should also be given the same benefit, Lordship, because I have passed, because I had the norms of 52.90 at the time of my regular appointment, Lordship. Instead of keeping the matter pending,
This
Lordship.
item number 17, we will keep it as parted.
Yes, lordship.
And the other matter we are disposing of.
Lordship.
Heard Mr. S.K. Das, learned counsel for the petitioner, and Mr. D. Upamanyu, learned standing counsel for the respondent in higher education department. And you, are you agreeing for any respondent? Respondent number 5.
This case, Lordship, petitioner's pension was settled in the year 2017. Lordship, but thereafter, after a gap of 7 years, Lordship, the director has forwarded a letter to recover them. Lordship, now we are nothing to say, Lordship, because recovery is to be done by the department or treasury. Lordship.
Finally, we will hear you
That is
on
my
the
stand, Lordship.
next day, we will hear you.
Item 18, Lordship, I'm submitting.
Item 18. Yes. You were not in 17.
Yes, item 18.
17. Okay. 17.
Heard in part, list the matter on. Okay. As Mr. Upamanyu, learned standing counsel for the higher education department, he will file one detailed affidavit. Accordingly, there is the law. List the matter as part heard on.
I may draw your lordship's indulgence for making a mention of 2 new writ petitions, my lord.
Pardon?
Of making a mention of listing of 2 new writ petitions. Now, urgent matters, it was required e-filing. That's why I couldn't mention in the morning. Now, this is regarding making admission of class 11 students under the Durban portal. One permission your lordship has allowed yesterday. That matter has come up before court number 24 today. Now, these matters, my lord, the government had issued the notification on 12th. The portal is open from 17th to 24th. My lord, if tomorrow I get a chance, I at least get 1 day. My lord, 2 writ petitions and 6 IAs in pending 6 writ petitions of last year. Now, there are interim orders passed in last year in those 6 writ petitions. We want similar relief for this year also, my lord. Won't take much of your lordship's time tomorrow.
When do you want?
Tomorrow, my lord.
Tomorrow.
My lord, because on 24th, Thursday, is the last day.
Okay.
2 motions and the IAs will be for orders.
Okay.
Abhishek.
For hearing 21 and 22.
My lord, I'm extremely apologize, my lord. Mr. Tamar was ready, but he have to go to home, some urgent domestic problem, my lord. On any day on next week, my lord, probably on Monday, my lord, 28th.
Hearing Monday. In the month.
Not on Monday.
May month.
First of May?
First week of May.
Month of May.
First of May, my
Second
lord.
week, Lordship.
Second week.
On 15th May.
On the pair being made by Mr.
PK Bordoloi, my lordship.
PK Bordoloi, learned counsel for the petitioner. With consent from the other side. The matter is then adjourned to be listed in the second week of May.
Timing item 9.
Lordship, here in this matter, affidavit was in reply was filed by the petitioner on the last date, Lordship. I was handed over a copy, Lordship. I need to file a small counter, Lordship, in this matter, Lordship. So a week's time may be granted, Lordship.
Against the affidavit in reply filed by the
Yes,
petitioner.
yes, Lordship.
They have just quoted my impugn order and filed the affidavit. It is under challenge. And what they reply they are going to give, my lord.
Lordship, a week's time may be granted, Lordship. A week's time may be granted, Lordship. File, Lordship.
The lady is, my lord, quite old, so urgent date, early date will be fixed, my lord. Deputy sir.
Borman, learned counsel for the petitioner, and Mr. D. Pomunyo, learned standing counsel for the respondent in higher education department. And Mr. P.J. Soikia for respondent number 4. Mr. Pomunyo submits that the petitioner herein has filed affidavit, the reply to the affidavit in opposition filed by the respondent authorities, and he will file counter to the same. And press for granting him a week's time. There is allowed recessal is the matter on 16th of May.
Item, timing item 10.
Non-payment of pensionary benefit to the morning also they have taken. Pension দিছে নি?
So you have submitted your pension paper.
My lord,
When?
long back, my lord. Immediately after my retirement in 2022.
And where it is pending now?
Perhaps in the my lord, secretariat office, my lord.
My lord, as per my instruction, this is my instruction.
Kindly page 59, my lord.
There's later dated, my lord, November 23, my lord, whereby the director, my lord, has written later, my lord, for granting GIS, GPF, etc.
And here, Office of the Accountant General, letter number so and so, has sought some clarification regarding the deputation period of Dr. Sutia at Lakhimpur DRDA. In this regard, some clarification has been sought from the Dr. Sutia, and Office of the Commissioner PNRD for onward communication with the Office of the Assistant Accountant General. Further, number 3 point further, file letter number so and so dated 13/3/2025, Office of the Accountant General has been requested to furnish a leave admissibility report. And on receipt of the leave admissibility report, leave salary will be sanctioned at this end, from the secretary.
So you have received this letter?
So everything is correct.
So what is the status of his regularization during the deputation period? Mr. Sharma?
Yes, madam. In this regard, I have to take instruction, madam.
Page 30 of my petition, my lord. Sanction is there. Page 30, my lord, regarding deputation. Deputy Secretary to the Accountant General, my lord. Later dated 28 November 1990. I am directed to convey the sanction of the Governor of Assam to the reputation of the following officers. I am one of
This is of the letter dated 28 of
November 1990. Sanction is there, my lord.
1994.
Sanction is there. That means, my lord,
But
the
they
reputation
have
is
not
regularized.
fixed the terms and this.
And next page, page 31, my lord.
Terms and condition of deputation were not fixed. They have sent a file to the finance department
lord.
and the
Next
finance
page, my lord.
department has regretted it. Now the matter is forwarded to the ARTP and PG department
My lord.
for views.
For simple things, my lord, they are taking 2 years, my lord. I am retired 2022, my lord. Now 25, 3 years, my lord. And for payment of GPS and leave salary, my lord, also, my lord, the sanctions are not required, my lord. For the purpose of pension, it is, my lord, required. So for regular pension is concerned.
No, their stand is that this period in which you are in deputation has to be regularized only 10 days PPF
That has
amount
been,
can
my
be-
lord, page 31, page 30 is clear enough, my lord. Sanction is there, my lord.
Page
So,
number?
page 30, my lord. And except for.
This is sanction and
Sanc-
regularization are two different.
My only prayer before this honorable court, my lord, your lordship may direct my lord to release the GPF and leave salary, my lord, leaving aside other my lord dues.
Oh, that is all over it. This deputation period is not regular, therefore they could not process the file. Have to file any application to the AG for withdrawal of the GPF amount?
No, my lord.
No.
No, my lord.
Here, my lord, in letter dated, my lord, 17/1/2025. Here, Joint Secretary has written the Accountant General Assam final withdrawal of GPF money in respect of Dr. Ramesh Chandra Sutia, retired Inspector of School, North Lakhimpur. With reference to the subject cited above, I am directed to forward here with an application and its enclosures in respect of Dr. Ramesh Chandra Sutia, retired Inspector of Schools, North Lakhimpur, who retired from his service on 31/8/2022, taking final withdrawal of GPF money from his GPF account number so and so. This is for your kind information and necessary.
I have written to the government, not to the my lord AG. Various representations are there, my lord.
So these are forwarded to the Accountant General.
Only 17/1/2025 you have forwarded it.
Yes.
Yes, what is the status of this letter? The instruction you have placed before the court today is dated 27/2/2025, where you have mentioned that you have not received the application for withdrawal of GPF amount. But this letter shows that the government has forwarded the letter to you. On 17/1/2025. You release the amount. You will
GPF and
release the
leave
matter
salary,
after 1 week.
my lord.
In the event of failing to produce the releasing letter before this court, the AG has to remain present in the court. Pardon, sir, please just second, learned counsel for the petitioner. Dr.
U. Sharma.
U. Sharma, learned standing counsel for the respondent number.
1, 3, 1, 3, 1 and 3, man.
1 and 3.
Yes.
And Mr. Learned standing counsel for the respondent number.
5.
Respondent number 5. The learned counsel for the respondent number 5 has produced his written instruction dated 27/2/2025. Received from the senior account officer, legal cell, office of the AG, Bamuni Madam Beltala. Oh no, Moidam Gaon Beltala. It is stated in the aforementioned letter that the office has not received the pension papers. No, neither received the pension paper nor does GPF final withdrawal application from the competent authority, and as such, the office would not act upon the petitioner's grievance. But Mr. Sharma, learned standing counsel for the respondent number so and so, has produced written instruction before this court. And also produce a letter dated 25th, no, dated 17/1/2025, which indicates that the application and enclosures in respect of the petitioner for withdrawal of his GPF money was forwarded by memo number E-42 6910 stroke 144 dash A dated 17/1/2025. Under such circumstances, the respondent number 5 is directed to release the GPF amount which the petitioner is entitled to within a period of 1 week from the date of receipt of a certified copy of this order. In the event of failing to release the same within a period of 1 week, the court will consider directing the respondent number 5 to personally present before this court. On next date. The instruction so placed on record by Mr. Sharma further indicates that the pension paper of the petitioner could not be processed as the deputation period is yet to be regularized. Then the file was sent to the finance department, and the finance department has regretted the same. And now the matter is endorsed to one ERTP and PG department for reviews. Mr. Sharma shall obtain up-to-date instruction in respect of the aforementioned file. Then apprise this court before on next day about the status, latest status. List the matter on for a short 1 week.
Sixteen May.
16th May. 16th of May. You have submitted about the GPF and the what?
Leave salary.
Huh?
Leave salary. That I am
Salary,
entitled.
that depends upon the regularization of your deputation period. And they have also asked for this leave admissibility report
Yes.
from the AG office. You have to furnish the up-to-date status of this admissibility report also. Along with this furnishing of leave admissibility report of the petitioner pursuant to the letter dated 13/3/2025. Issued by the Joint Secretary to the Doctor of Assam Department of School Education. On next day.
Obliged.
Ready to open the date.
Coming again, 33.
As per the interim order of 25/9/2024, provisional pension at the rate of 35,950. Only with a date from 1/2/2024 till the date of finalization of the pension by the Director of Pension Assam is hereby sanctioned by the Forest from the Decca, the then Headmaster of Patigaram Vidyapit High School, Gurugram, on 31/01/2024. Lordship, we have done our part, Lordship. And thereafter, Lordship, the petitioner, along with the bills, he submitted this order and his bills to the treasurer of his Lordship, in the treasurer of.
No, this is sanction order, whether the amount was credited in his account or not.
Lordship,
No, my lord. My lord, this
How-
letter just I have received, I have gone through it. There is a sign this made, signature is made 1/11/2024, but yet memo there in some time, some hand, it is written
29.
and in November is made March, my lord. So I think some doubt is, my lord, there, my lord, after going prima facie. Although I accepted her submission, but this letter I have just received my phone in April 10. Still there is a direction. If it is in March, so why this direction is given? I don't know. There is some confusion. There is a confusion. I just received, and he says that nothing has been done. In fact, and this letter also says that memo number is different, signature is different. It is the April 10. Again, direction is given to the contaminers, this inspector of the school, they comply with the direction. So if it is done in March, why in 10/4? Something is not clear, my lord. But fact is that he has not received a single penny till today.
Lordship, inspector part is only to sanction the provisional pension, Lordship.
Who will prepare the bill?
Yes, he has prepared the bill and petitioner has collected the bills from the office of the inspector of school and then submitted it to the in the office of the treasurer, Lordship.
When?
Lordship, after collecting the order, Lordship.
Pardon?
And bills. After collecting the order dated 29/03/2025 and the bills from the office of the inspector of school, Lordship.
Mr. Borua, you do one thing. You inquire it from the treasury officer, Payata Sariyale,
Yes.
Whether this order was received by them,
Yes.
then whether any step is taken for crediting the amount in the account of the petitioner.
That may be done, my lord.
Heard Mr. M.J. Borua, learned counsel for the petitioner, and also heard Miss
K. Bharali on behalf of Mr. B. Kaushik.
K. Bharali, learned counsel, appearing on behalf of Mr. P. Kaushik, learned counsel for the contempt. During the course of deliberation, Ms. Bharali has produced one sanction order dated 29th of March 2025, sanctioning the provisional pension of the petitioner. But Mr. Borua submits that till date he has not received a single penny.
Yes.
Single penny. In view of the sanction order dated 29th of March 2025, Mr. Borua shall obtain necessary up-to-date instruction from the petitioner as to whether he received any amount of the provisional pension and advise this court on or that. 5th of May. The order produced before this court today shall be part of the record.
Obliged.
Item 19 for hearing.
Please, your lordship. Lordship, I have instructions from my senior to appear in this matter and argue.
Pardon?
I have instructions from my senior to appear in this matter and argue the case. It's been a very long pending 1010 matter.
Yes. Okay, are good?
Yes, Lordship. Lordship, there has been some, because this matter was earlier, it was heard at length heard at length, and it was also part heard couple of times and again released, wherein Lordship, there was some directions by the erstwhile honorable judges to submit written submission, Lordship. So I'm not sure whether written submissions was submitted or not. So Lordship, I have prepared one. So I'd like to
Okay.
place it again if it is not there in the. Lordship, I will go a little slow, Lordship, with the things. Lordship may kindly bear. Submission. Lordship, the facts of the case starts like this, Lordship. The petitioner was appointed as an assistant teacher, Lordship, of a ME school way back in the year 1994, Lordship. Lordship may kindly peruse page number 26. Or Lordship may produce page number 24, that is the typed copy of the page number 26, the appointment letter. It's '24, Lordship.
Page number?
Page 24.
Yes.
By the Office of the District Elementary Education Officer, Bongaigaon, it reads as per approval of the advisory board and subject to discharge without notice and reason thereof, Shri Devdut Nath, he is the petitioner, Lordship, son of Walnut, is hereby appointed against the newly created post for assistant teacher of middle schools and allotted post to Shantidham Kalibari ME school in the scale of pay of rupees this. The post was originally created and allotted by government order number this dated 16/11/1991 and DE Assam memo dated this one. This is the appointment letter, Lordship. After that, Lordship, he joined accordingly in the next month, and on being given the salary for the next 3 months, on June 1994, the salary was stopped because of the that committee report, Monoran Committee, Lordship. Up till May, he got the salary and then the salary was stopped. However, Lordship, the services were not terminated and he continued without payment of salary. This was on June 1994, Lordship. Then, Lordship, in the year 2000, after that, Lordship, he was continuing in that school without salary. But then on 24/2/2005, there came up a cabinet decision to regularize the teachers who were otherwise at that time alleged to be appointed as illegal or irregular teachers, Lordship. And based on that cabinet decision, Lordship, there was one order dated 30/1/2006, that is 30 January 2006, wherein, Lordship, 125 teachers were regularized. Lordship may peruse that order at page 37, Lordship. Annexure 5. Page 37, Lordship. That's by the Office of the Director of Elementary Education, Assam, Kahilipara, and it says if in exercise of the power conferred upon the Director of Elementary Education by the government dated this, and in pursuance of the government order memo dated this, issued on the decision of cabinet meeting held on 24/2/2025 that I just mentioned before, your lordship, for regularization of services of 2,276 numbers of teachers of LP, ME, MEM, HS, HSS teachers of the state who were appointed in excess of post during the period 1/3/1991 to 96. Lordship must skip over all these things, and then next, lordship, screening committee, departmental screening committee, the services of 125 teachers of ME, MEM, MV working teachers of Bongaigaon district are hereby regularized with effect from and the date of their joining against the vacant post as per enclosed list. And with this order, lordship, a list was also given wherein the names of the 125 teachers regularized by this order on the basis
Your
of
name
that.
is in the list?
Yes, my name finds a place. Page number 39, lordship may produce. Under serial number 36, my name finds a place in the list. Devdut Nath. In the upper side, lordship may produce. Page 39. Post against which adjustment is proposed. Ranjit Chakraborty, 80, retired. So in this post, I was allotted as regularized teacher, assistant teacher. Lordship, after this, lordship, I joined in the school, lordship, where I was given the allotment.
So 42 is the joining report.
Lordship?
Page number 42 is the joining report.
Yes, lordship. Yes, lordship. But then, lordship, when I went and joined the school, then I found that the post, it was not a vacant post. Teacher was already there. So, lordship, I made correspondences with the, complaint with the authorities and all. There were various correspondences. Lordship may peruse page number 48. Page number 46 is this typed version of the page number 48, lordship, wherein upon correspondences made by the petitioner, there was a letter by the District Elementary Education Officer, Bongaigaon. The letter says, lordship, with reference, is your lordship at page number 46. With reference to the subject cited above, I am directed to request you kindly specify the vacant post against the following teachers to be readjusted, lordship, not regularized, to be readjusted, where already regularized their services by the directorate in pursuance of the order dated, that is 2006. And the lordship may produce the next page wherein 8 number of teachers, name of 8 teachers, my name finds place at the serial number 7. So the amongst the 125 teachers who were regularized, wide order dated 2006, these teachers were given a post wherein the post was not vacant, lordship. So there was a plea to the authority concerned to readjust the allotment. However, lordship, petitioner joined the place that was given to him and he was continuing, although not a vacant post. He was serving there. Then Lordship, there were many correspondence here and there. There were some RTI applications were also made by the petitioner because amongst these 8 teachers, 6 were given adjustments, but the case was of the case of the petitioner was not considered. So he being frustrated, he went to the RTI concerned and all. So upon RTI, he could find that some particulars was not up to the mark. So he again went and gave her his particulars. And finally, Lordship, after all these things, in the year 2009, fresh proposal was given by the DEEO stating adjustment to the petitioner. Lordship may find that order, page number 60. Page number 60. By the Office of the District Elementary Education Officer. Lordship may peruse the contents of the letter. With reference to the subject and number cited above, I have the honor to submit herein the SIU Finance Department format, which is required from your end for adjustment or regularized of services in respect of Nodul Chandra. Nodul Chandra is the petitioner number 2. However, Lordship, he is not continuing in this matter because he's already retired. And for the petition number 1, Devdut Nath. Nodul Chandra De and Devdut Nath. Their name proposed in the present lying vacant post in Bengali medium LP schools due to both the applicants belongs to Bengali medium, the necessary information indicating this one. With this, a proposal pro forma thing was given. Next page, Lordship. That where he was readjusted, Lordship. Lordship may peruse page number 63. Last part, Lordship. Lordship may see line in functional, the post proposed for adjustment of this service to Devdut Nath, vice Shri Shishu Ranjan Kor, 80 retired. Shantidham Kalibari, ME school, that column. Upon regularization, he was given a post in Vivekananda, some school, wherein the post was not vacant, Lordship. Then with this order, along with this proposal, he was given the vacant post at Shantidham Kalibari school. Now, Lordship, with this things being in the favor of the petitioner, he went on. But then the authority told the petitioner that there is an interim order which is restraining your allotment to be given. With the interim order, Lordship may find at page number 72. At that point of time, Lordship, there were many cases came up in the High Court with this Monohan Committee and illegal and irregular teachers and all. So, Lordship, in the year 2009, 19/1/2009, in a case, writ petition number 5569 of 2002, Honorable Justice Ranjan Gogoi passed this order, which was, according to the authority, coming as a hindrance for execution of his fresh proposal, Lordship, for the petitioner's fresh proposal. And the relevant portion, Lordship may see in the next page. If I may read, Lordship. Because the subject matter was same. So the interim order says that as the written instructions placed before the court today by the learned departmental counsel Shri M.R. Pathak would seem to suggest that there is a proposal for further regularization of irregularly, illegally appointed teachers whose names find mention in the report of the Manoharan Committee. To strike the correct balance, the court is of the view that the state respondents should be restrained from regularizing such illegally and irregularly appointed teachers. It is therefore ordered accordingly. Lordship, if I may again press this line, should be restrained from regularizing such illegally and irregularly appointed teachers. That means what, Lordship? Further, I mean, regularization was restrained, Lordship. Whereas, Lordship, in my humble submission, my case, 2006, that 125 teachers list, I was already regularized, Lordship. My case was of readjustment to a vacant post. Lordship, now in this point, petitioner came up with this writ petition, Lordship. We filed the writ petition in the year 2010. Lordship, there was at that point of time in the year 2010, 2008, 2009, 2011, there were batches and batches of writ petitions filed in this particular context, Lordship. And Lordship, my writ petition was tagged with another writ petition. I mean, in the batch, my writ petition was also tagged, Lordship. So it was coming as a batch. But Lordship, there has been another case, case number 1048, Lordship, wherein an order was passed. I came to know about this case and this order from the rejoinder that has been filed in my petition, Lordship. Now, Lordship, if your Lordship may take the rejoinder filed by them, because that order and the case that was, I find the details there itself, Lordship. Rejoinder.
Chair, you have been again appointed.
Yes, Lordship,
As per this Annexure 15.
I will be coming to that, Lordship. Before that, Lordship, on 2000, okay, Lordship, on 2010, that writ petition was the other writ petition of the same context that was passed with an order to the education department that it says like this, Lordship, as accordingly, as per terms of the order dated this in the writ petition number this, the education department placed the matter of regularization of illegal and irregular teacher before the cabinet in its meeting held on 26/2/2011. Page number 84 of the rejoinder, of the affidavit in reply. I was not knowing about this order and also about this case.
Are you in service now?
Yes, Lordship, but that is a different thing because I am in service as a tutor, Lordship. I will be coming to that point, Lordship. Thus, before that, this things needs to be cleared. That's why.
Where is that affidavit?
Lordship, it was filed recently on 2024.
Our affidavit will start from page 81.
Yes.
81.
81. Running page number.
Yes.
And I am on page number 84, Lordship.
That is our affidavit.
Their reply, their opposition, affidavit in opposition.
Yes.
Paragraph 8. Yes, Lordship. In the paragraph number 8, they have stated accordingly in terms of order dated this one, 2010, passed by the Honorable Court in writ petition this, the Education Department placed the matter of regularization of irregular teachers before the cabinet in its meeting held on this. Thereafter, the Education Department proposed to constitute screening committee, this. this is their part, Lordship. They have accordingly dealt with the total, I mean, this appointment related thing in this manner. But my case was 2006, 2005 cabinet decision, 2006 order, 125 teachers list, and then Lordship, the interim order, in the case where the interim order was passed, that case was dismissed in the year 2012, 25/6/2012. I have got this order wherein it says that it needs to be,
Whether it is part of the record.
no, because it was not there in, I could not collect the certified copy also. It was on a day when this matter came up before Honorable Retired Justice Bujor Mollo Ochinto Mollo Bujor Burua. Then your Lordship, then his Lordship was pleased to call for the record. His Lordship has seen the thing, and his Lordship has passed this order. Lordship may produce. It is the case wherein the interim order was passed. Thereafter, Lordship, there were many instances, oral as well as written. The petitioner went to the authorities concerned and all those things happened. And finally, in the year 2021, Lordship, till 2022, nothing was there. In the year 2021, that is on 31/2021, the Director of Elementary Education issued an order accommodating the petitioner as tutor, Lordship. Lordship, I find that accommodating order at page number 80.
Page number
80.
Last page of the amended writ petition.
Last page of the amended writ petition.
Last page of
The amended writ petition. The writ petition was amended, Lordship. The amendment was allowed and it was
Annexure 15.
Annexure
15.
15. The last page. Lord.
Prior to deadline.
Page 80, Lordship. Annexure 15. Lordship, the writ petition was amended. Is your Lordship taking the amended version or the previous writ petition, Lordship?
Yes.
Yes. Lordship may find my name.
Yes, yes.
The post again, Lordship may see below the table, the post against which the appointee is accommodated, Lordship. as tutor is purely personal in nature and will cease to exist as and when the incumbent retires from service or expires, then Lordship may skip over 2 lines and then Lordship, the 3rd line, Lordship may say, the accommodated tutor will get the prospective effect from 01/11/2020 only, and he or she cannot claim any benefit whatsoever in respect of past services rendered by him or her prior to 1/01/11/2020. Lordship, I have already read out this part, although it goes against me, but the thing, Lordship, as an answer to this, Lordship, I have been appointed with this with this order as a tutor, and I'm continuing as a tutor, Lordship. But here, Lordship, I want to make out a case. If your Lordship may now read page number 16, para number 11A. Lordship, this needs to be considered, Lordship, on what circumstances I have been pressurized, if I may use this word, to take up this order, Lordship. I was without salary, languishing in this post, although being regularized by an order way back in 2006, Lordship, for nearly 19 to 20 to 21 years, Lordship, without any salary. So, Lordship, and Lordship, what is the clause that has been attached with this order that I cannot claim any benefit for my services right from 1994 to 2020, Lordship. Lordship may kindly allow me to read para number 12B, the next page, page number 17. That the petitioner begs to state that he had been suffering for the last 26 years without getting any salary, and as such, he was exasperated, Lordship. Further, so far as the state government is concerned, he was a small man who had no bargaining power or choice but to accept the aforesaid letter. Lordship, no salary for such a long period of time. I was given this and I had to. Next, Lordship, it is stated that the bargaining power of the state and the petitioner is unequal, and he had to accept the accommodation under compulsion, as stated herein above. The aforesaid condition is an unjust one, and the state cannot resort to the theory of take it or leave it. That was actually the condition, Lordship. It was given as a take it or leave it kind of a thing, which is violative of Article 14 of the Constitution of India and also Section 23 of the Indian Contract Act 1872. The petitioner has his right to get his salaries for the aforesaid period, and the unjust condition cannot be thrust upon him. Moreover, such a clause in a contract of employment is opposed to public policy, and the state cannot interfere with the rights of the petitioner. So this is the thing that I'm trying to make out before your Lordship. At this juncture, Lordship, I would like to place a case record, case law. I have given it is of 2003, 1 SCC 591. Hindustan Times and others versus State of UP and another.
Relevant paragraph?
Lordship, I will be relying on paragraph number 39, but before that, Lordship, I would like to read out to your Lordship the factual matrix of the case, Lordship, if I may be allowed by your Lordship. Lordship,
On this point, no further case law is required, all right?
Lordship, pardon, Lordship.
So this will suffice.
I will be, I was,
In
trying
connection
to,
with the same point,
Lordship, pardon?
you want to submit another case law on the same point,
Yes, I have Brojon and Ganguly also I will be citing, but
on the
I,
same point.
yes, same
This
point.
regarding bargaining power,
Yes,
not necessary. Okay, all right.
okay.
Any other point?
No, in this particular point, this case and the other case.
Hmm.
And from this case, I will be relying by paragraph number 39, along with the factual matrix of the case, because in this
Okay.
case also, Lordship,
Okay.
now Lordship, if I skip over this bargaining power thing and the accommodating order of which the benefit I have taken, and I am there as a tutor now. If this part goes, Lordship, now I will try to convince your Lordship regarding the that 2006 list of 125 teachers, how it has been dealt with by the different courts till now, Lordship. The last order that I have got, Lordship, was of the year 2024. There were many teachers who were in this list, and those teachers were not getting the regularized salaries and all. How the courts have dealt with. These are the orders of various courts of the year 2017 as well as 2024, wherein the courts have directed the authorities concerned to make an inquiry and release the salaries. The list concerned is that 125 list only, wherein my name is also there, Lordship. And Lordship may kindly take note that I was regularized way back in 2006. My case was only for adjustment of my vacant post. Lordship, one thing, if I may show it to your Lordship, the order that was passed in writ petition 6681 of 2010, Vishnu Ranjan Kalita. The order was passed by Honorable Justice, now retired, Achinta Malla Pujar Burwa. Paragraph number 4, Lordship, if I may read out, Lordship. Lordship, may I?
Paragraph number
4.
Yes.
From a reading of the order dated 31/2006, this is the same order, Lordship, where in my case also, wherein the list was there. It is apparent that the services of 125 teachers included in the enclosed list were regularized by the order dated 31/2006, and such regularization had taken place after being inquired by the Manoharan Committee and Task Force district level screening committee, etc. In such view of the matter, it cannot be said that the regularization of the enclosed teachers, including the petitioners, were made dehorse the procedure followed at the relevant point of time in respect of such categories of teachers like that of the petitioners. But in spite of being so regularized and adjusted, it is the case of the petitioner that the salaries and allowances were not still paid. Lordship may now skip over all this. Then Lordship may come to page number 8. In this at page number 8, Lordship, this paragraph, he has dealt with the interpretation of the interim order that was hindering my appointment also. Adjustment, sorry. Lordship may see from the first, second, third, fourth, fifth, sixth, seventh, eighth, ninth, 10th, 11th, 12th, 13th. 13th line, Lordship. Further, has your Lordship got Lordship?
Yes, sir.
Further, the order dated 19/1/2009. This was the interim order, Lordship. Further, the order dated 19/1/2009 of this court in the concerned writ petition at best provides that further regularization of the teachers under the Manoharan Committee be banned. In any view of the matter, the said order is to be construed to have prospective effect, that is that from 19/1/2009 further regularization cannot be given effect to. The said order cannot come to the aid of the respondent authorities for not paying the salaries to those teachers who have been regularized by the order dated 30/1/2006. This is how the interim order has been dealt with. Right?
Okay.
And then further, Lordship, there was direction to give the salaries and all. And there was also a finding, Lordship, at paragraph number
This order in WPC number 4791. This is incomplete. You file it complete. Okay. Page number 2 is absent there.
Oh, then this copy may be taken.
Okay. Yes. So what is your
Here,
stand?
my lord, petitioner is admittedly illegally appointed, my lord. Initially, they have illegally appointed.
No, illegally appointed, that's all right, but your committee.
My lord, that committee, my lord, was prepared. This, my lord, this what my lord, learned friend relying, the list, my lord, prepared 125 teachers. Here, my lord. Kindly see that school, MD school teachers of Bongaigaon district proposed to be regularized by the government. That is not regularized, proposed to be regularized. After that, my lord, they could not join in their service. That means they have not regularized in their service. And admittedly, they have appeared before the screening committee. That was constituted as per the order of this honorable court. Kindly see our affidavit, my lord. Page 93, Annexure 1. Cabinet memorandum, man.
Yes.
Second paragraph. In terms of the Honorable High Court's final order dated 2/3/2010 passed in WPC 1048/2004, the Education Department placed the matter of regularization of irregular teacher before the cabinet in its meeting held on 26/2/2011, with a view to examine the nature of appointment, status of post, working status of salaries, academic qualification, etc. The Director of Elementary Education Assam invited application from this illegally appointed teacher during 1991 to 2001 throughout the state by an advertisement dated 1/2/2012 and 4/2/2012 in the local newspaper. In response to the aforesaid advertisement, applications were received from such category of teacher. After preliminary examination of the applications received at the director level, the Elementary Education Department constituted a 5 screening committee headed by the division commissioners concerned and principal secretary of 6 scheduled areas to examine these applications. Preliminary committee's report. Here, my lord, petitioner appeared before the committee, my lord. As per these advertisement, my lord, petitioner appeared before the committee and submitted his documents. Kindly see page 89 of our affidavit, para 14. That the answering respondent humbly begs that petitioners fall under the category of illegal irregular appointees, hence they participated in the said screening process and submitted their documents. Upon verification, the name of the petitioner find in place category number 3, that is not recommended but working till that. And as per the aforesaid cabinet decision, the petitioner who fall under the aforesaid condition were offered fresh appointment and with prospective effect from the date of cabinet decision aforesaid to their qualification. Here, petitioner fall under the category number 3. That is category 3 is kindly see page 87. Teachers who neither receive salary nor qualified or training. That is DBT or DLL. That is we have explained in page 87. List 3. Teacher who neither receive salary nor qualified training, that is DBT or DLL. Petitioner has not receiving their salary. They have not having the required qualification. That is why they fall under category number 3. Thereafter, accordingly, they have appointed as per the cabinet decision in the year 2021, which they have accepted. Thereafter, in that year 2023, they have amended this writ petition. Accepting all the conditions, they have accepted their appointment in the year 2021 itself. Now they are challenging this. Cabinet decision was.
So, you have submitted that they are proposed to be regularized. But this page number 46, annexure 7, you come to page number 46.
Page number 46.
Ah.
This is submitted by the deputy director, regularizing the service of the teacher under EMC. With reference to the subject cited above, I am directed to director request to kindly specifically specify the vacant post against the following teachers to be readjusted.
Who were already regularized in their service.
But as per the select list, who is my learned friend is relying, that is page 38. Page 37 is the order, 30 is the 38 is the list. Here, top of the line. MEMV school teachers of Bohanga district proposed to be regularized by the government. Against the post against which?
No, you come to 37 page number.
Yes, Lordship.
Education Department in persons of the government order memo number 20 dated 12/1/2006 issued on the decision of cabinet meeting held on Iman for regularization of services of 2,276
Are hereby regularized.
Who were
Are hereby regularized with effect from the date of their joining. Against
true,
the
my lord, they have not joined, my lord. She has not, the petitioner has not joined, my lord. Because the specific school which he has allotted, my lord, there he could not join, my lord. Already, because already one teacher, as per my submission of my learned friend, one teacher is there.
No, thereafter she submitted that he had joined there and rendered service there.
Then, my lord, they have asked the kindly see page 48. This is kindly specify the vacant post against following teachers. Here again, my lord, this letter has expressed that there is no vacant post. By this letter, asks to specify the vacant post, my lord.
That joining report is there.
True, my lord, already another teacher was there, my lord, in the. Another teacher was already there, my lord.
You see the endorsement of the headmaster there in page number 43. He is allowed to join. Page number 43. And 42. 43 is the original copy and 42 is the type copy.
But then petitioner should have received the salary.
You have not
Again, my lord,
released
he
it.
has, again, my lord, he is claiming that
You
another
have
teacher
not
was there, my
released
lord.
it.
My lord. Again, he is claiming that another teacher was there, that is why asking for adjustment in another school.
Lordship, we were continuing in that school till 2020, Lordship. Lordship may also produce
But
the
without-
working
without
certificate
salary, my lord.
without salary, Lordship. Without salary, obviously, because we were hopeful that we will be getting the things done with. Working certificates were also
Page
number 77, Lordship may produce. 76 is the type copy. 76. This working certificates dates is dated 2/9/2010.
That is up to
That is
2010, my lord.
Yes, when
And
the
they have filed this case,
when
ma'am.
the petition was filed, and thereafter, Lordship, how can I come up with the
Means they
working
have not
certificates? But
continued, my lord.
Lordship,
That is why they accepted this, my lord, appointment in the year 2021. Now, my lord, in the year 2023, they have amended this writ petition. Since 21, they have receiving their salary after accommodation. If they should have any objection, well, they have to come immediately, my lord. And another petitioner has already retired, my lord.
that's true, Lordship.
Maybe that does not mean that you will not grant him the benefit he is legally entitled.
Now, my lord, he is on verge of retirement. My lord.
Maybe.
Yes,
He is, then, my lord, he should have come earlier, my lord.
No.
I have come in the year 2010 itself.
But now, after accepting the appointment as per, my lord, 2021 in the illegal irregular category, now petitioner is pressing this petition.
I have already submitted in this land, Lordship. It is now for the Lordship to decide.
Let us provide a copy of the written argument, my lord. We will file a written argument. Okay.
Madam, you come to this page number 3 of your written argument.
Page number?
Some dates are not incorporated there. It is vacant.
Is your Lordship referring to that one? Subsequently, the interim order was. I'm so sorry, Lordship. It has to be, if I may put it in, it has to be 25/6/2012. I have already given the order, Lordship. I have provided with the copy of the order.
So you want to file a written argument?
My lord.
Why it is necessary?
They file it, my lord, I have not.
No, sir. They may file a written
I have
argument.
not gone through their
It does
argument.
not mean
Written
that you have to file it.
An extra paper I will be giving you.
I have not gone through this written argument. That is why I'm asking and go through it.
There was a direction from the court. I don't remember the date of the judicial orders, wherein the court directed both of us to file the written submission. So most probably I have already submitted on the last few before occasions, but I don't remember exactly. That's why I have given a copy again today.
Because this matter was earlier part had, my lord. On that round, my lord, I was not there, my lord. One of my friend is arguing there.
And on that direction wherein there was a direction to submit written submission, they filed their affidavit in opposition.
Okay. We'll keep it as part heard, Ms. Ida's learned counsel for the
Part
petitioner.
third.
And Mr. Bora for respondent authorities. Heard in part, list the matter on COVID.
1, 3, 20, and 4. Second. 1, 3, and 4. Respondent number 1, 3, and 4.
Respondent number 1, 3, and 4.
22nd May.
20
Sorted, COVID sorted.
22nd May.
Yes, Lordship,
Sorted.
13th May. 13th May.
30. In the meantime, Mr. Bora, learned counsel for the petitioner, may file a written argument, if so advised. The copy of written argument filed by Ms. Das, learned counsel for the petitioner, shall be furnished. A copy of the same be furnished to Mr. Bora during the course of the thing.
Deeply obliged, Your Lordship.
Hmm. 24. 24.
None appears for the petitioner on call. How Ms. You were present?
Lordship.
Oh, respondent number?
Lordship, second verification, Your Lordship. Lordship, on the last occasion, I had placed the instructions where the sanction was given for the area amount, Your Lordship, and the petitioner had sought time to obtain instruction from his client, Your Lordship.
Petitioner is absent today.
Lordship, but the amount has been sanctioned and I have a verbal Lordship instruction that the petitioner has drawn the amount on.
That instruction is not available in
It's
the
on
court.
page 40, Your Lordship, marked as an X, annexure X, Your Lordship.
Page number 40.
40, Your Lord. Flag X, Your Lord.
So let the petitioner come.
Lordship. Otherwise, the petitioner has drawn the amount, Your Lordship, on 20th of February.
On?
20th of February, 20 February.
Then why the matter is pending?
Lordship, because on the last occasion, the petitioner had sought time to obtain instructions whether they have received the amount or not. But the verbal instructions that I have received and the central schools of Kamrup had clarified that he had received them. He had received them.
How about Ms. Musa, right? Learned is pending something for the respondent present. And Ms. Musa submits that. Ms. Musa referring to the letter dated 28/11/2024 submits that the amount has already been sanctioned. And as per our instruction, the petitioner has received the said. Be that as it may, release the matter after a week on COVID. Sorted. About the TV. 30.
Lordship, on 30, I'll not be available. Other council may be available.
Anyone can present.
Lordship. Obliged.
25.
May I, may I please, your Lord? Lord, the matter relates to Milord. Lord, what has happened, Milord? The petitioner had been working as a district program officer in the Assam Sarva Shiksha Officer.
District
Program officer, Milord.
program
DPO,
officer.
my lord.
Yes.
In the Milord district of, while he faced the Milord suspension, he was a district program officer under SSA, Milord, in the Dhubri district. Now, my lord, what has happened while discharging his duty in the said capacity, a false case has been lodged against him that I have asked for bribe from one of the teachers for doing the needful of his clearance of his arrear salary. An FIR had been lodged, my lord, case had been registered, and I was arrested, my lord. And accordingly, my lord, as I had been arrested, my lord, put behind the bar, no formal suspension order, nothing had been issued, my lord. And once I, my lord, got the bail from the learned court below, my lord, or from the special court, honorable special court, my lord, then I approached before the authority that I should be allowed to resume my duties as I have been allowed to go on bail as a, my lord, a follow-up consequential action. But the authorities, my lord, has not, my lord, done anything, no suspension order, nor I have been allowed to, my lord, resume my duties. Now my position is till date, my lord, from the date of my arrest till date, my lord, I am hanging, no salary, no subsistence allowance, my lord, even I have not been allowed to work. They are only plead at, my lord, as I am a contractual employee, so therefore I do not have any right. Now they are required to take a final call, my lord. With all respect, my lord, my humble submission before my lordship is that they are required to take a final call. Either, my lord, they can terminate me or release me or remove me, or, my lord, I should be allowed to continue my job, my lord. That is, nothing has been done. Now, my lord, this is the factual metrics of the case, my lord, and there is a letter issued by the, my lord, Sarva Shiksha Abhijan Mission, wherein, my lord, they have said that for the contractual employees also, my lord, they are going to follow, my lord, the Assam Services Discipline and Appeal Rules of 1964. Just for a moment, my lord, I beg to draw my lordship's attention, my lord, to that page, at page 44, my lord, Annexure 7. What Milot says that save is otherwise expressly provided in the service regulations and so and so of the Assam Sarva Shiksha Abhijan Mission, it is hereby notified that the spirit of the rules and procedure as prescribed under the Assam Services Discipline and Appeal Rules 1964 followed by the Government of Assam for inquiry, departmental proceeding, award of punishment, appeals, etc. shall be followed by the Assam Sarva Shiksha Abhijan Mission as and when an inquiry or departmental proceeding are required to be conducted in respect of any employee, contractual or otherwise, employed under Assam Sarva Shiksha Abhijan Mission. Now, my lord, this is a clear and specific unambiguous order, my lord. They have been issued that for the purpose, the spirit will be followed. Now, in the affidavit, my lord, they have said only spirit, not letter. That means, my lord, they follow the spirit, but it will not practically they are going to apply, my lord, the affidavit which they have filed. Now, my contention before my lordship is that, my lord, as there is a clear. Now, my lord, what is my position? Till date, they have not, my lord, informed me. They have said that the, my lord, departmental proceeding is going on in their affidavit, but it has not come to a logical conclusion till date, as per my instruction, my lord. That is my
So
situation.
they have started the proceeding against
They
you.
have started the proceeding, but my lord, even the formal charge memo, my lord, which is required to be, my lord, in such a situation, with all my limited knowledge, my lord, what I respectfully beg to submit is that a formal charge memo appended with a list of allegation, list of documents, till date has not yet been served to me, my lord. Only some so-called notices has been issued. To that, my lord, I have responded to the same also, my lord.
Where?
My lord, before the authority, I have annexed, my lord. I have annexed, my lord. May be pleased to find those, my lord, is a part of the record. If my lord may be pleased to take up the last lord page at page 70 is the, my lord, no, 69.
68 is the, my lord. Page 71 is my reply to the so-called notice, my lord. Dated Dhubri, the 23rd of September 2022. Screen 920. And so-called notice, my lord, may be pleased to find is at page 66, annexure 13, my lord. To that I have replied, my lord. My lordship has got it, my lord, at page 66, my lord. So-called notice, whereas it has been brought to the notice of the undersigned that you have been arrested by a team of Directorate of Vigilance and Anti-Corruption, Assam, in connection with accepting the bribe money amounting to rupees 10,000 for an individual, and you were arrested by the police vice so-and-so of 1988. Whereas being one of responsible official in the mission, you have violated the office decorum, office procedure, responsibilities and commitments to the mission, and such type of work indicates your irresponsibility and the gross negligence of your assigned duty. This kind of irresponsible behavior is totally unacceptable and against the work ethics. In view of the above, you are hereby asked to show cause as to why stern disciplinary action shall not be taken against you for being involved in such type of works. Your reply must to the undersigned within 7 days from the date of receipt of this notice, failing which the disciplinary authority shall be at liberty to pass an appropriate order ex parte. Now, my lord, responding to this, I have replied, my lord, is at page 71, my lord. Reply of the so-called notice dated with due respect and humble.
Already you have submitted your reply.
My lord, I have submitted.
Thereafter, what happened?
Thereafter, my lord, there is nothing, my lord. There no charge memo, no, my lord. Only.
Yes, Mr. Soturi, you
My
are
lord.
appearing for SSA.
Yes.
What happened to thereafter? What happened to him thereafter?
Lordship, we have stated in our affair, there was a hearing
was
of both the complainant and the petitioner. And thereafter, now at what stage the inquiry is pending, that instruction I do not have, Lordship. But the hearing took place. Evidence also placed before the authorities and the petitioner.
As per this Assam Service and Discipline and Appeal rules, you have to furnish the search sheet along with
Lordship,
the list of witnesses. and
Lordship,
the
first of
documents.
all, the petitioner is a contractual employee. In contractual employees case, Lordship, we can go for direct termination. But the spirit in the sense of the Assam Service Discipline rules is that giving him a so-cause notice and thereafter he can reply and taking evidence thereafter. That's the spirit, Lordship. It doesn't say that each and every step of the Assam Service Discipline and Appeal rules will have to. We are just complying with Article 311, Lordship, giving him an opportunity to reply against the allegation, Lordship. That's the inquiry at what stage is now pending. That instruction I do not have, Lordship, whether the full inquiry has been completed or the authority is in the process of taking a decision. That instruction I do not have. Otherwise, Lordship, evidence has taken place as per our affidavit, Lordship.
No, whether a proceeding can be conducted without furnishing the search sheet, without furnishing.
Lordship, first of all, Lordship will have to take into account he is a contractual employee. He is
Maybe.
bound by the terms and condition of the act.
There are decisions of Supreme Court that even in case of contractual.
Lord, a very recent judgment has been delivered, my lord.
Pardon?
A very recent judgment has been delivered, my lord, wherein I have found it, my lord, today itself. That, my lord, for the purpose of contractual employees, my lord, the full proceeding is required, my lord, because it is the case of principle of natural justice is required to be followed. And when the concept of natural justice will come, then the allegation basing on which what are the material available with them, if those are not furnished, my lord, then the principle of natural justice in fully cannot to be said to be fully complied with, my lord. That's why, my lord, they have in this letter which they have communicated, the Sarva Shiksha Abhijan Mission has taken care of, my lord, all the things, my lord, all the law which are available, that why the Assam Service Discipline and Appeal rules is required to be followed, my lord. Just with a stroke of a pen, a man's career, my lord, cannot be tarnished. My lord, kindly, my lord, appreciate, my lord, I have family, I have given all, invested all the time. Some mistakes is there on my part, my lord. For that, such a major punishment without a salary from last 3 years, my lord. The man, my lord, the petitioner who has come to my chamber, my lord, is very pathetic, my lord.
Whether he is not entitled to subsistence allowance?
That is also
Lordship,
not
under the
providing.
contractual, under the contract agreement, Lordship, there is no such substance. Only the
No, whether in the contractual agreement such a terms are set?
My lord, the contractual agreement I have also annexed, my lord. I have not found that any debarment of such, my lord. If my lord may be pleased to
Lordship,
take
because
up.
the SSA employees are all are either on contract basis or on deputation basis. Lordship, there is no service rule as such because it's a purely coterminous with the scheme.
No, sir, that is correct. My respected senior friend is correct that we are contractual, but my lord, for the purpose of contractual, you cannot keep a person in such a manner like a, my lord, in a slavery mood, my lord.
No,
That,
the
my
question
lord.
is whether a contractual employee during the period of his suspension is
what
not
he will do,
entitled
my
to subsistence allowance.
Lordship,
Whether his right to life and personal liberty as guaranteed by Article 21 is not violated.
Lordship, I have found.
Or denial of this subsistence allowance.
I have found citation, Lordship, where the VC is placed under suspension. Recently, what happened in Dibrugarh University, Lordship, as well as the Krishnakanta Hendik Open University. If it is not, there are no rules on not governed by any agreement. Lordship, subsistence allowance may not be given. That
That's
Lordship,
all
today I do not have.
No.
I will
Mr.
produce it.
Sudhuri, where there is no rule, there the principle of natural justice will come into play.
And that's why, Lordship, the SOCOS notice on that basis, Lordship, that OM order issued by the mission director, Lordship, that the spirit of the Assam Service Discipline, and that's the procedural part. So that none is deprived of knowing what allegation is against him.
No, my lord, the issue is not that, my lord. The departmental proceeding which had been initiated more than 2 years back, my lord. Now kindly assume the situation, my lord. I am now neither, even a formal suspension order they have not issued to me yet. Automatically, as I have been behind the bar for more than 48, my lord, Rule 6(3) will come into play as a deemed to be
That's all right.
suspended.
Where is the suspension order then?
Till date, it has not been issued to me, my lord. I am assumed to be in duties, my lord. If I claim today that I have been illegally debarred from, my lord, my lord.
Lordship, here, Lordship, that part I do not have any.
No, that is in the affidavit also there, my lord. They have filed their affidavit. There is nothing said that, my lord, I have in my specific paragraph, they are silent, my lord.
That
Suspension
Lordship,
order
I
they have
can
not.
get it clarified, Lordship. I can.
You can clarify, that's all right, but
Subsistence
why yours affidavit is silent on that point, that whether he is placed under suspension or not?
Lordship, if anything is on the record, if Lordship allows me, I can bring it on to additional affidavit, Lordship, if Lordship permits, Lordship. Because that aspect is not there, Lordship. I have gone through the affidavit, I have seen it, Lordship. That is not, I'll try to get it clarified.
Very pathetic condition. If my
Very
lord,
pathetic, that's all right. After 1 week, you produce the
My-
record. And
Yes.
also, you apprise this court about the latest status of this departmental proceeding. Heard Mr. Bhuya of Bhuya, learned Air Bhuya, learned counsel for the petitioner, and Mr. P. Chaudhuri, learned standing counsel for SSA, and Mr. Sharma for respondent number. Respondent number 1.
Respondent number 1, Lordship.
1. And Mr. Solia for respondent number 2. Respondent number 2.
For 3 and 4, Lordship.
Mr. Solia for 3 and 4. During the course of hearing, Mr. Bhuya, learned counsel for the petitioner, submits that the petitioner has already been placed on suspension.
No, my lord, I have not been placed under.
That's all right. Statedly, the petitioner has been placed on suspension, but the suspension order till date has not been furnished to him. And the affidavit filed by the respondent number 3 and 4 are also silent on this point. To a pointed query of Mr. Appointed Query, Mr. Chaudhary, learned standing counsel for the respondent number 3 and 4, submits that he may be granted some time to place on record the suspension order before this court. Mr. Chaudhary further submits that departmental proceeding has already been initiated against the petitioner, and hearing also took place on some dates, but he is not he is not aware of about the latest status of the said departmental proceeding, and he prays for granting him some time to apprise this court about the latest status of the departmental proceeding initiated against the present petitioner. Where is accordingly allowed, raise the matter on
5th May.
5th of May.
I have got some other, any other date thereafter.
7 May.
Malik.
7th of May.
Lord, may I pray for keeping the matter as a part heard?
Okay, raise the matter as part.
Malik. Obliged, highly obliged.